Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. It is 9:30 on September 20th, and we are moving forward with our general session that was agendized for today. We will start with a roll call of commissioners.
Thank you, Mr. Chair. Commissioner Bogue, Commissioner Gonzalez.
Here.
Commissioner Hackett, Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 5 out of 7 commissioners present.
Okay, great. Good morning, everybody. I see we've got 31 attendees. Welcome, folks, to the Colorado Oil and Gas Conservation Commission meeting this morning. We have on the agenda one item that is docket number 2011000261, and it looks like we are getting our attorneys with us for this docket. I see Mr. Jacobs and Mr. Mueller for KPK, and Ms. Stafford and Ms. Rosenberg for the director and staff. In order to start this morning, let's just talk a little bit about case presentation and time and order of presentation. We did receive an amended pattern of violations final pre-hearing order from Hearing Officer Peskin dated September 16th, and I believe that was to try to orient that to the discussion that the commission had following the September 16th matter. I think I've got one slight edit to that. This is on page 3, Roman numeral 4, subparagraph A8, which says Commissioner deliberations regarding pattern of violations. And my recollection is that we were going to have A, order of case presentation on pattern of violations, B, order of case presentations on inability to pay, and then commissioner deliberations on all of the foregoing at one time. So I propose that we strike A8, and otherwise I think the time and order of case presentation as outlined in Roman numeral 4 is appropriate. Would note that I will recuse myself from penalty or corrective actions as relevant to the NOAVs that I've recused myself from. I will plan on participating in pattern of violations and inability to pay deliberations, as well as deliberations on penalty and corrective actions on the 5 matters that I was not recused or did not recuse myself from. Do any commissioners have any further procedural matters at this time? And then I'm going to call upon the parties to see if they've got any procedural matters. Okay, seeing nothing further from commissioners, Ms. Stafford, Ms. Rosenberg, do either of you have any procedural matters at the outset here? And are you okay with the deletion of A8?
Thank you, Chair Robbins. I don't believe staff has any procedural matters to present to you at this time. And we are in agreement with your proposal regarding A8. I think that would be in accordance with what the commission ordered this past Thursday.
Okay. Mr. Jacobs, Mr. Mueller, do you have anything at the outset here? And are you comfortable with the A8 deletion?
Thank you, Mr. Chairman. We are comfortable. It was on my list to raise that, so you anticipated that, and so we're certainly okay with it. I note that the order also has closings after pattern violations. I think we contemplate a closing after all of the evidence is in, including ability to pay. But my colleague, Mr. Jacobs, will correct me if I'm wrong about that.
No, I agree, Mr. Mueller. Mr. Chairman, if I may. I believe we specifically mentioned last Thursday one closing, one opening statement, and that was one of the benefits of the restructuring of the hearing.
Okay, Ms. Stafford, Ms. Rosenberg, do you have thoughts about that? It seems sensible to me, but I haven't heard from you yet, so I will refrain from saying that.
I don't believe staff has any objections to this particular proposal.
Okay, then let's, on our respective pieces of paper, move A6 and 7 to B3 and 4, so that there's a one closing following both of the issues that are going to be brought up over the course of the next 2 days. Yeah.
Does that mean openings are consolidated as well? Openings will address both?
Yeah. Hey, AAG Davenport had a good idea or a good question. Do you guys want to have one consolidated opening, or do you anticipate doing a short opening on pattern of violations and a short opening on inability to pay? Mr. Mueller, go first.
I defer to my colleague, Mr. Jacobs. He's our opener, but I think we have one consolidated opening.
That is correct. I concur.
Ms. Stafford, you can do it however you like, but if you could let us know how you anticipate doing your opening, that would be helpful.
Thank you, Chair Robbins. I think our opening, contemplates all of the issues that we were dealing with in relief. So I don't think we have an objection to doing it in a consolidated manner.
Okay, so consolidated openings, consideration of pattern of violations, evidence and testimony, consideration of inability to pay, evidence and testimony, one consolidated closing for each side, and then we'll move into deliberations. Anything further from either side?
Not on behalf of staff, Chair Robbins.
Nothing further for KPK, Mr. Chairman.
Okay, then I believe we're ready to roll. So at this time, we would turn to Ms. Stafford and Ms. Rosenberg for a opening, followed by KPK's opening, staff's presentation, KPK's responsive presentation, and then the presentations on inability to pay. Let me ask one further procedural matter. Mr. Mueller, Mr. Jacobs, the way this is set up, staff's going first on pattern of violations and you're responding. And the way this is set up, you're going first on inability to pay, and staff's responding. That seems to make sense to me. Are you in agreement with that? I just want to make sure we've got everything dialed in before we jump into this.
We are in agreement. Correct me if I'm wrong, Mr. Jacobs.
We're in agreement. Thank you.
Very good. Staff, we will now hear from you on opening.
Chair Robbins, just briefly before we open, just to respond to the inability to pay presentation, I do want to note again that staff has not taken a position on KPK's inability to pay here, so our response will be fairly short.
I note that from previous testimony and positioning on behalf of staff, and that's fine.
Thank you.
And Ms. Larson will be keeping time. She's nodding her head up and down. And I believe each side has 2 hours exclusive of commissioner questions. Ms. Stafford.
Thank you, Chair Robbins, and good morning, commissioners. I'm Caitlin Stafford, Assistant Attorney General and Counsel for COGCC staff, in docket number 201100261 et al. Staff's enforcement action against KP Kaufman Company. I'd like to reintroduce my co-counsel in this matter, Kelly Rosenberg, COGCC Enforcement Officer. Following your finding in the previous phases of this hearing that KPK violated 22 separate commission rules, we are back here today to present to you as part of the third phase of this hearing. This phase of the hearing concerns appropriate relief for KPK's repeated violations of commission rules and is focused on whether KPK has engaged in a pattern of violations. Commissioners, last month I told you that this case was about an oil and gas operator that consistently fails to comply with the commission's rules. I told you that through the actions staff had alleged, staff would show you that KPK was unreliable because they could not and cannot meet deadlines or approved timelines. I told you KPK was incapable because they could not and cannot fulfill their obligations to the COGCC by operating in a manner that minimizes threats to public health, safety, and welfare, the environment, and wildlife resources of the state of Colorado. And I told you KPK was impactful because they could not and cannot timely and adequately clean up the messes that result from their frequent and repeated spills and releases. And staff's allegations were borne out by the pleadings, the evidence, and the testimony in this case. The commission found 22 separate violations of Cogcc rules and calculated a penalty. Now, commissioners, you are asked to determine the full scope of relief that is necessary as a result of KPK's systematic and widespread problems operating in compliance with Cogcc rules. The first component of this relief is corrective actions. Staff has asked that you order KPK to perform all required remediation and reporting at any and all NOAV locations with soil or groundwater impacts. Staff has also asked that the commission order KPK to use qualified individuals specifically trained and experienced in environmental field practices related to soil and groundwater characterization at the NOAV locations. These corrective actions are actions that a responsible operator would have already taken not only at the locations we heard about last month, but at all of its oil and gas locations across the state. Through our presentations today, staff will show you that it is imperative to order KPK into full compliance with Cogcc rules before they are allowed to continue operating in this state. Second, and importantly, staff has requested that the commission find that KPK has engaged in multiple patterns of violation, and as a result, apply an aggravating factor to the penalty without consideration of ability to pay, and to suspend KPK's certificates of clearance until all required corrective actions are completed. A finding of pattern of violations is necessary here based on KPK's history of noncompliance, as evidenced by the violations you've already found as part of this enforcement matter, and prior orders entered against KPK, including the recent Rule 901A order. Through our presentations today, staff will show you KPK has engaged in not one, but multiple patterns of violation. During this phase of the KPK enforcement proceeding, you will hear presentations from Jeremy Farron, John Axelsson, and Cogcc Director Julie Murphy. In his presentation, Mr. Farron will walk you through what it means to find a pattern or patterns of violation, including requirements under Rule 525, past orders imposing a finding of pattern of violations, and KPK's pattern of violations. Mr. Axelsson will present to you on KPK's history of noncompliance with Commission's rules, the facts leading up to the issuance of the Director's order pursuant to Rule 901A, which required KPK to take immediate action at 29 separate locations subject to remediations for past spills and releases of oil, gas, or E&P waste, and corrective actions that should be imposed in order for staff to regain trust in KPK's operations. And Director Murphy will provide concluding remarks on the impacts of KPK's operations and the necessity of holding KPK fully accountable to the Commission to ensure those impacts are properly addressed. Much like the previous phases of this hearing, it is staff's burden to demonstrate that the relief requested here is appropriate under the circumstances. And that burden sets forth a single question. Is it more likely than not that KPK has engaged in a pattern of violations? If it seems like a pattern, it likely is a pattern. As set forth in the pleadings, in the documents in the record, and in prior orders and accompanying information available in Cogcc, KPK is a repeat rule offender that requires additional corrective actions to return to compliance. Multiple Commission orders establish their history of violations, and KPK has been found in violation of, and KPK has committed 22 separate violations as a result of this hearing alone. KPK has engaged in patterns of violation prior to this case, within this case, and as a result of the findings of this case. Staff requests that you find KPK has engaged in a pattern of violation, apply an aggravating factor to the current penalty, suspend KPK's certificates of clearance, impose sweeping corrective actions, and order any other necessary and appropriate relief. Thank you.
Thank you, Ms. Stafford. I now believe we will hear from Mr. Jacobs for opening on behalf of KPK.
Just a moment, Mr. Chair. I'm going to share a screen and use slides for my opening.
We will start the timer when you say you're ready to go.
Thank you. Can you see my screen?
No, we cannot. Ms. Amaro, does he have screen sharing?
Let's try that again. Are you able to see my screen?
Not yet.
Oh, here we go. Sorry. My apologies. And now,
Yes, we can see your screen, Mr. Jacobs.
thank you very much. Mr. Chairman, Commissioners, staff has not met its burden on pattern of violation in this proceeding, in this consolidated proceeding. Staff must demonstrate that KPK is responsible for a history of noncompliance such that it persistently and potentially intentionally disregarded legal requirements or the Commission's authority. The evidence offered does not demonstrate that KPK is responsible for a pattern of violations, as that phrase has been interpreted and applied by the Commission previously, consistent with Rule 525B. Regulatory guidance, rulemaking history, and administrative precedent establish that a pattern of violations means not just a handful of violations, but wrongful conduct that rises to the level of recalcitrance and defiance, and that is pervasive relative to the size and scale of the company's operations. As KPK's evidence and testimony will demonstrate, staff has not met this burden of establishing a pattern of violations. More specifically, the violations alleged to constitute a pattern are factually distinct or minor and infrequent. Of the 8 prior KPK enforcement orders from the past 35 years, 1 was for a violation of Rule 324AA, and 2 were for violations of Rule 906B. These 3 prior violations over the span of at least 12 years, coupled with new violations for an operator with 1,300 oil and gas wells, scarcely constitutes a pattern. Moreover, the activities and events giving rise to the 3 Rule 324AA violations have no common pattern other than triggering a violation of a broadly worded general duty rule. Finally, the 906B violations regarding reportability are all minor. Likewise, other factors do not reveal a pattern. Staff asserts other factors are revealing of a pattern, but none exists. 4 NOAVs involve complainants, 4 involve releases from flow lines, 5 involve inadequate response, and 5 involve missed corrective actions. These are sweeping generalizations by staff attempting to identify a pattern of factual similarities, but not a pattern of violations. And while the 901A order has been allowed to be considered by your ruling, it does not establish or even allege violations, but only expresses concern about spills and releases and an alleged lack of progress in remediating them. Additionally, staff's use of spill information in the 901A order is misleading. Staff selectively compares KPK to another operator in an attempt to show that KPK's spills are excessive. KPK witnesses and exhibits will demonstrate that such a comparison is misleading and prejudicial, and KPK is about average over the last 6 years in its number of spills relative to the number of wells operated. Additionally, staff fails to note that many spills are caused by third-party conduct, which is the subject of KPK witness testimony. Moreover, staff uses data for the time period when the threshold for reporting spills dropped from 5 barrels to 1 barrel. So spills increased during that time period for all operators. Additionally, you will hear testimony that KPK has upgraded many miles of flow lines. Staff has implied that KPK facilities are unduly prone to leaks and poorly maintained and repaired, but that is simply not the case, as KPK witness testimony and even COGCC staff documentation establish. KPK has routinely gone well beyond the COGCC requirements in its work to repair leaks from flow lines, upgrading significant lengths of flow line every time it addresses a leak. And COGCC staff have expressly recognized this on multiple occasions. And KPK often is the victim of third-party strikes or line crossings that cause leaks from its fiberglass flow lines through no fault of KPK's, as its witnesses and exhibits will also demonstrate. KPK has made significant progress in remediating NOAB and 901A order locations, contrary to staff's allegations. Staff also asserts that KPK has been slow in its remediation efforts, but this is misleading. KPK has made substantial progress at most locations, as documented in periodic reports by KPK, none of which has been specifically responded to by staff. Locations where progress is slower are generally affected by historic contamination, lack of access from third-party operators, and delay associated with staff review and comment, as well as surface owner restrictions, among other factors. Also, KPK's voluntary assumption of the expense of remediating other operators' historic contamination has also contributed to a slower rate of progress. Finally, KPK has a limited ability to pay and also to perform corrective actions by a date certain. KPK has weathered the 2014 commodity price crash and even the pandemic thus far, but staff seems blind to these challenges. KPK's expert forensic accountant has opined that KPK's ability to pay is substantially less than what staff seeks in the way of penalties and sanctions. KPK's expert economist also opines that over-deterrence resulting from excessive penalties and sanctions can be counterproductive, as reflected in the available economic literature. Yet staff has taken no position on ability to pay and ignores its inclusion in the enforcement policy altogether. KPK has a promising future and stands ready to partner with Colorado in the energy transition that has already begun. KPK is poised to play a critical role in achieving Colorado's GHG emission reduction targets. The Spindle field is unique in its capacity for large volume CO2 sequestration, while also enhancing production of oil from existing infrastructure. KPK's land position in the Spindle field is a huge asset for Colorado to leverage in the need for sequestering carbon from large point sources not easily converted to renewable energy given current technology and cost constraints. Proximity to Denver is also key to the Spindle field's availability for this purpose, as these diagrams indicate. Harnessing KPK's production revenue, not preventing it, is key to a return to compliance. Staff asks the Commission to issue a corporate death sentence. Staff does not acknowledge or address the likely consequences of this. Penalties, corrective actions, and suspending certificates of clearance will not promote a return to compliance. Far from it. Acknowledging KPK's ability to pay and structuring a settlement that harnesses the economic engine of its production to promote quicker remediation, reasonable penalty payments, and projects in lieu of penalties is far superior to staff's approach of seeking maximum sanctions and ignoring altogether the likely negative consequences for the state of Colorado, not just for KPK. This commission has the tools to do this. KPK has made mistakes and is committed to correcting them and returning to compliance. We do not deny that mistakes have been made and we need to improve, but that is not an admission of pattern of violation, which staff has not proven. Rather, KPK is committed at the highest levels to returning to compliance and developing a collaborative relationship with staff, but it takes two to accomplish this. KPK would welcome Commission direction to engage staff regularly regarding its progress, and even to submit to a settlement master or mediator in addressing staff's concerns beyond the imposition of sanctions that will not threaten the company's continued existence or the livelihoods of its hardworking 150 employees. Thank you.
Thank you, Mr. Jacobs, for the opening on behalf of KPK. We will continue forward, and at this time, I believe we will turn to staff for the presentation that they promised in the opening with regard to certain witnesses. Ms. Stafford, Ms. Rosenberg.
Thank you, Chair Robbins. As I mentioned in our opening, first you will be hearing from Jeremy Farron, who will be delivering the first presentation on behalf of staff.
Good morning, everyone. Can you hear me?
I'm just going to break it.
Yeah. Before we move into Mr. Farron, let AAG Davenport get involved for purposes of swearing in witnesses as we go through.
Thank you, Chair. Commissioners and parties, I propose just simply a reminder to any witness that has previously been sworn in that you remain under oath, and would request that the parties, if they have any witnesses that have not yet been sworn in at any point in this consolidated matter, that they remind me so I can swear them in the future.
Excellent. Thank you, AAG Davenport. With that, Ms. Stafford, your first witness.
Thank you, Chair Robbins. As I mentioned, Jeremy Farron will be presenting first.
Good morning. Can you all hear me? I kind of lost you. I can't see you any longer.
Yes, we can see you and we can hear you, Mr. Farron.
Okay, great. I apologize. I don't know where your faces have gone. So if you need to interrupt me, please do. But I'm just going to dive in. Good morning, Commissioners. Jeremy Farron, Enforcement Supervisor. I am happy that we were doing sort of a presentation style at this point. So I'm just going to dive in. First, to give you an overview, I want to talk about patterns of violation generally. Then I want to move on to KPK specific patterns of violation. And as I said, if you all wouldn't mind interrupting me with questions, I think that's best for everyone. But I'm just going to jump in. I've spoken to you previously about patterns of violation, and if you are to find a pattern of violation, that gives you sort of 3 tools that you can then apply to the situation. And one is a larger penalty. It's an aggravating factor. It can act as a multiplier. Second is suspending an operator's certificate of clearance, and I'll talk about that a little bit more. And the last is withholding new drilling or oil and gas location permits. KPK is not an operator that drills a lot of new wells, and staff looked in the records that they did not have any pending, so we're excluding consideration of that third option. But I do want to circle back to certificates of clearance and talk about what those are.
If I might interrupt briefly, Mr. Farron, your slides aren't advancing.
Oh, looks like they are on my end. Is it still on the initial screen?
Yes.
Mr. Farron, you're not in presentation mode.
Let's hold
Yeah,
on
sorry.
and try to get this going again.
Thank you for interrupting. What about that? Can you see, is that a second slide?
It is a slide. I don't know if it's the second one.
Yes, that's the second slide. I will continue then. Certificates of clearance. A certificate of clearance is the authorization for usually a third party to remove hydrocarbons from an oil and gas lease. That's a document that is approved by staff. It's an important document. I think I've been told that without that authorization, it could be considered theft for those hydrocarbons to be removed. So those are the 2 options that I think we can discuss here today. And of course, I'm not advancing now. There we go. Did that advance?
It did.
Great. So we're looking at the rule 525D. We spent a lot of time last week talking about subpart 3. I will skip that, and we're going to focus on subpart 2. And specifically, there's 2 phrases in there I want to discuss with you. The first is sort of what we just mentioned, what options you have should you find a pattern of violation. Again, KPK has no pending permit, so we're excluding consideration of that. I want to give you a little bit of background about patterns of violation and a pretty drastic shift in the enforcement program that occurred in 2014. Prior to that, there was an enforcement program, but it had pretty limited ability to fine operators. And it didn't have the language that appears in 525D now. It didn't have that ability to suspend a certificate of clearance. So 2014, we went through a pretty serious rulemaking and changed essentially the whole enforcement program. And so for orders with patterns of violation that predate 2014, I haven't really considered those. I consider them irrelevant because there was such a seismic shift in 2014. But I do want to talk about this second bullet point, which is that since 2014, the Cogcc has yet to suspend certificates of clearance for a functional company. They have done so for what I would call a non-functional company. So gross non-compliance, complete non-responsiveness, occasionally operators that still have people around, but are just not complying. And so we end up issuing an order that revokes their authorization to operate in the state of Colorado and claim their bond. We call them bond claims. So since 2014, those are the only certificate suspension orders that exist. It was for gross non-compliance, sort of non-functional companies. And before you today is the question of whether you should enter an order that suspends Kpk certificates. And I would say that, if this situation does not justify it, it's never going to be used. This is the poster child for using that additional tool that has yet to be used against a functional company. I want to talk about Exhibit A to our initial brief, which is a listing of Kpk certificates. That is a comprehensive list. It was pulled right out of the database. It is all of their certificates at all of their wells. I apologize, that's a pretty busy exhibit, and I wanted to explain some of it. Some of those certificates have been superseded. They're no longer valid. Sometimes you can have multiple valid certificates covering multiple transporters and gatherers. Some of those certificates are even duplicative, but they're still valid. So I would suggest that before you today, you have 2 options. You can suspend all certificates, so suspend everything that is listed in Exhibit A. Or if the commission wishes to suspend a subset, I would suggest that you suspend all certificates pertaining to a particular enumerated list of wells, however you want to enumerate that list, those certificates that are currently in effect. So you'll see a little language there on this slide that could help you if that's the route you want to go. Again, I think this is the poster child for using this, and whether it's all or some, personally, I would suspend all. I think it's important to send a message here, but if you want to do a subset, I would suggest you do something other than go through Exhibit A and pick individual document numbers, because that's not going to get you where you want to go. So that's the discussion of Exhibit A. The second clause in 525D that I wanted to talk about is this: if you enter such an order, it's then incumbent upon KPK to return to the commission and demonstrate to your satisfaction that they've returned to compliance, paid the penalty. And at that point, you, the commission, can vacate that order. And that's, I think, maybe a subpart to this tool that is a little underappreciated, because at that point, they're beholden to you. They need to return to you. They need to convince you that they have, righted the ship. And I think that's a subpart to this tool that's important, because as we've said repeatedly, they don't seem to want to listen to us. They don't seem to want to pay attention to the direction of staff and the director. And I think employing this tool, like I said, shifts the burden to them to come back to you and convince you. And at that point, you can help manage their return to compliance. I touched on this. These are the historic patterns of violation that have been found. I did not review those that preceded 2014. I will say that the first 6 are that category that I talked about, which were sort of gross noncompliance, non-functional companies. That those were those sorts of orders that would revoke an authorization, claim a bond, and put an operator out of business. Interestingly, we did not impose a percentage increase in penalty. We did not apply an aggravating factor and increase penalties. And I apologize, I was involved in many of these orders. I don't recall specifically why we did that, but if I had to guess, I would say, you know, we were entering orders that we knew no one was going to pay, so why bother aggravating the factor? And I'm sure Kpk is going to point to those orders and say that, you know, you can enter a pattern of violation and then have no aggravation to the penalty and, you know, result in a 0% increase. And that's absolutely true. And, you know, that's the precedent, those first 6 orders. But that, I think, was a different factual situation where, you know, for instance, that 6th order energy source, that's like a $1.2 million. We had no expectation they were going to pay. We knew what that order was going to do. It was going to shut them down. You know, if you aggravated it up to 1.5, what difference did that make? And so that's what I seem to recall we were thinking at the time. So that's the first 6. The last 3, 7, 8, and 9, magpie extraction and sandridge that you see on this list, that I think is a better precedent for Kpk. Those were and are functional companies. They had non-compliance, you know, patterns, and we aggravated the penalty in 2 instances 10% higher, and in 1 instance, 2 instances 20% higher, and 1 instance 10% higher. So I think those orders are the precedent you should be looking at. And like I said, Kpk is going to point to those first 6, but I think the latter 3 are more appropriate for you to consider. Magpie still in existence, still operating. Extraction still in existence, still operating. Sandridge sold most of their assets. I don't believe they have much in Colorado, but it was a different situation where we were applying that penalty to a functional company. I touched on this, the difference between, you know, pre-2014 and then, oh, I'm sorry, let me scoot back 1. The 2 on the bottom are highlighted because those are post-181. That did not have much of an impact on what staff was doing in those cases, but, you know, just for your reference, those are post-181 orders. So yeah, 2014, different story, and then post-181, you can look at things differently, I think. So shifting to the patterns that we believe have been found in the prior parts of this case. Kpk is engaged in 2 different patterns. They have engaged in patterns that are based on prior orders, and I'll talk about those. That's 324 and 906. And then there's patterns within the current case. And you don't need to look much further than those patterns, which are pretty self-evident. But I'll talk about each one. The first is a violation of 324 big A, and that is predicated on a prior violation of 324 big A that was entered into an order 1V181 back in 1999. 324 big A has been on the books for quite a while, hasn't changed much over that time, and, you know, was awfully similar back in 1999. I went back and read that order over the weekend and was struck at how similar that situation was to many of the NOAVs you've heard recently. Had a large spill impacting a stream, and Kpk failed to respond adequately. They failed to contain the contamination. They failed to provide requested environmental documentation. It read like many of the NOAVs we have been discussing over the last few weeks. I just want to note the penalty was severely limited because of the existing rules. So that really doesn't have anything to say about what we're looking at here. But with that order entered in 1999, and then the near miss matter entered in this proceeding and the soil spread field, there's a clear pattern, 324, you know, 3 instances of violation. If that's not a pattern, I don't know what is. So that's 324. Next, 906. 906, remember, spill reporting. Again, I looked at the prior 2 orders, and that's 1V725, 1V728, both entered in 2020. And they read awfully similar to NOABs in Grant, Tank, and Gilson. It was a failure to report a spill, failure to notify local governments, failure to file an initial Form 19, failure to file a subsequent Form 19. Those facts seem awfully similar to those that you have found in Grant, Tank, and Gilson. And again, I think that's a pretty clear pattern and pretty hard to find that there's not a pattern. Mr. Jacobs just mentioned, oh, but they were minor impacts. Doesn't matter. That's not written anywhere in the rule that the pattern needs to be for moderate or major only. A pattern is a pattern. And it was only through, I think, luck in some of these situations that they were only minor impacts. So those are the patterns based on prior orders. Shifting to the pattern identified of 901C, which is, recall, the requirement to provide environmental documentation. In this case, in this docketed matter before you all, you have found 3 different instances of violations of 901C. Charles Schneider, NESU number 1, and NESU consolidated. That, again, is a clear pattern of non-compliance or inability to comply with 901C, and I think it is a predicate for the finding of a pattern of violation, and the third such predicate. The last pattern is 907A, which is proper storage or improper storage of EMP waste. This commission over the preceding weeks has found 3 separate instances of violation of 907A, and that's at the NESU number 1, the near miss, and the soil spread field. All similar factual situations, all found in prior hearing dates before this commission. So there is, again, another the 4th pattern that the commission can point to if they're so inclined to find a pattern of violation. So with those patterns in place, I want to shift to 525C, where we talk about, this can then be applied as an aggravating factor. Once you find a pattern, you can apply an aggravating factor. If the commission were to do that here, that would increase the existing penalty, as I calculated it based on the deliberative documents posted on the website. At present, the total penalty is roughly $1.8 million. If you were to apply a 20% increase, as we've suggested, and I'll discuss how, that would bump the penalty up to $2 million. And I would suggest that you apply that 20% increase for all instances of 324 Big A and 906B, because those had the prior orders. So the next finding of a violation of 324 and 906, it would be appropriate to aggravate that penalty. And the second category of violations that exist within this case, 901 and 907, we would suggest that you apply that 20% aggravating factor to the second chronological instance of that violation. And that hopefully makes sense, because the first violation is not the pattern, but the second violation establishes the pattern. So with that, you go from a $1.8 million penalty to a $2 million penalty. This is a very busy slide. I don't expect you to review it in detail, but this is how I did that math, tallying up the existing penalties to date and then applying the aggravating 20% factor. I have provided this spreadsheet to Ms. Larson, so if during your deliberations you want to play with these numbers, I would suggest doing it in that spreadsheet. But you'll see I've denoted the first instance to let you know which was the first instance, and thus no aggravation applied. And then they're color coded by each particular violation. So hopefully that's a helpful document when you get to your deliberations. But that's how I got the number from 1.8 up to $2 million. So just to summarize, we're asking that you find that KPK is engaged in multiple patterns of violation. And there's 4 very distinct patterns. identified in this record. The 2 based on prior orders and 2 found within this docketed matter. And of note, you might want to look at the Sandridge order for a precedent of finding a pattern within a docketed case, because that's what happened in that case as well. So, like I said, pretty clear pattern, kind of hard to argue that there's not such a pattern. And, you know, if some of those had minor impacts, that should not sway you from finding the pattern. So with that pattern in place, we're asking you to deploy 2 of those tools provided by the rule. First is applying the aggravating factor to the penalty, as I've suggested. And Ms. Stafford noted this, but it would be beneficial, I think, to enforcement staff and to the regulated community if you applied that aggravating factor to the penalty initially without consideration of ability to pay. That would tell us, you know, a lot about how we would need to apply it in the future, how industry should consider that application into the future. And then once you have a number in mind, and I'm suggesting that $2 million, then you can take that, you know, consideration of ability to pay and apply it to that $2 million. And I think that would be helpful, because in the future, if there's a situation where we have similar findings, but an operator who's not claiming an ability to pay, we would appreciate knowing, you know, how to suss these things out without that potential confounding factor getting in the way. So that's just a request for, you know, for staff's purposes in the future. But like I said, we want you to apply that aggravating factor because there's a pattern, and I think it's appropriate to apply it. And then the last, suspending Kpk certificates, either all or some. I've said it before, if this is not the case where that tool is to be deployed, I don't know that that tool will ever be deployed. I think this is a situation where we need to do something, and the imposition of a penalty might have that effect. I don't know that it will, and I think having you know, application of that third tool is probably something that's going to get this situation corrected and get KPK back where we want them to be. So I think that's all that I have. I can open it up to questions, and I assume also some cross-examination.
Thank you very much. Mr. Farron, if you could stop the screen share, that would be helpful. Okay, now we can all see you. At this time, I believe it's appropriate for me to acknowledge Mr. Jacobs for purposes of cross-examination. Then we would give Ms. Stafford a chance for redirect, and then there may be questions from commissioners. Mr. Jacobs.
Mr. Chairman, thank you. I just have a few questions for Mr. Farron. Mr. Farron, did staff follow the existing enforcement guidance and penalty policy in its calculation of penalties for the alleged violations in this consolidated OFB hearing?
I believe we have.
And yet staff has not applied the ability to pay factor and takes no position on it, even though that's provided in the enforcement policy. Is that correct?
That was a discretionary decision that we chose not to exercise that discretion and kick it up to the commission to make that call.
Thank you. And staff has not provided a written basis for departing from the enforcement policy in that regard, has it?
No, I don't believe we have.
Further, Mr. Farron, am I correct that it is Rule 525C3 that allows the commission to increase the penalty to the statutory daily maximum amount based upon a finding of POV, pattern of violation, as an aggravating factor?
Yes, correct.
And what is the statutory daily maximum amount that a penalty can be increased to based upon a finding of POV?
It's up to 15 grand per violation per day.
Where in the statute rules or Cogcc enforcement and penalty policy does it state that staff may apply a percentage increase up to 20% that exceeds the statutory daily maximum of $15,000 per total penalty, not per penalty per violation per day, as provided in 525C3?
I'm sorry, I don't follow your question. Can you rephrase that?
Well, I believe that the language of 525C3 caps the aggravating factor to $15,000, not 20% of hundreds of thousands of dollars, or doubling this from $1 million to $2 million. You disagree?
I still am not following. Are you suggesting that we should apply that aggravating factor to the individual daily penalties?
No, that the language of the rule provides that the aggravating factor is capped at $15,000, period. Not $15,000 times violations times days. The language of the rule is quite clear.
Well, then I will direct the commission to read that rule and interpret it how they see fit.
That's fine. Thank you. In the 3 prior instances where staff has applied a 10 to 20% penalty increase on a per rule violation basis, did staff ever increase the penalty by more than $15,000 for each of the rule violations where a POB finding was found?
I don't recall the math, so I can't answer.
Okay. I submit to you that you mentioned the 1999 order that you read over the weekend. This was order 1N-181, I believe. Is that correct?
Yep.
I submit to you that that involved a DCP spill that KPK responded to, and that was deeded to KPK after the spill, but KPK cleaned it up. Can you confirm that?
Don't know the background.
Happy to provide information on that and would like the opportunity to do so. Hardly a violation establishing a pattern if in fact a third party caused the spill.
Except that KPK has an order entered against them, so I don't know why that would change the finding, right?
I believe you're speculating, and I'm happy to provide some facts. I'd like the opportunity to do so. Thank you. Lastly, if you could share the spreadsheet you showed and we'll be providing to the commission with opposing counsel, we'd appreciate that very much. I have no further questions.
Ms. Stafford, any redirect?
I have none. Thank you, Chair Robbins.
Commissioners, questions for Mr. Farron? Commissioner Gonzalez?
Thank you, Chair. Thank you, Mr. Farron. I had a question about the certificate of clearance and kind of the effects of suspending those. Do any of the corrective actions that are being sought here or that are part of the NOAVs require a COC in order to accomplish them?
No, I don't believe they do. You don't need to produce a well and sell product from the well to clean up the contamination that has, existed out there in the environment. So I don't believe so.
So
it might be a question for Mr. Axelsson. He knows those details more than I do, but my initial take is that no.
Okay, yeah, and I'll ask Mr. Axelsson the same question. I guess my concern is that if you have a live operation or a live well and it is connected to flow lines or has some connection to the hydrocarbons below the surface, that there may be something involved in including bringing some of those hydrocarbons to the surface and moving them as part of the corrective action. So that's a question if you're not prepared to answer, I'm happy to defer to Mr. Axelsson.
And let me be clear. So the certificate of clearance stops you from selling product. It does not stop you technically from producing your well. You can produce your well to a tank or to a battery or what have you. You just can't remove those hydrocarbons from the location. It has the impact of forcing you to shut your well in, because why would you fill a tank if you can't sell that product? So to the extent I think that you would maybe need to run a line to, continue with the remediation, I think you still could. You couldn't sell the product once it reached your tank.
Okay, so the COC is more to, I guess, removing. I was confused by the language you used about removing hydrocarbons. So it's not removing them from the earth; it's actually removing them from location. So you can pull as much hydrocarbons out. You can store them however you need to, take them as far as you need to, so long as you don't sell them.
Yeah, so it's the authorization generally for a third-party transporter or gatherer to remove your gas, or show up with a truck and remove the oil, or better, put it into a pipeline. So it's removing those hydrocarbons from the lease. That's the authorization.
Okay, thank you, Mr. Farron.
Other commissioners with questions? All right, I'm doing two things at once. I'm looking at my notes to see if I have questions, and I'm looking at commissioners to see if they have questions. Mr. Farron, the 20% that you're advocating for, where did that percentage come from in previous orders?
I think it was just an individual decision. I think the first instance was that Magpie order. That was a negotiated order. We came up with that percentage through negotiation. I wasn't intimately involved in that matter. And then since then, it's kind of acted like precedent with the extraction in the Sandridge. Sandridge was a 10% as opposed to a 20%. But yeah, I think that's the genesis of that is simply that it was negotiated. And since then, that has seemed like a fair amount. I could also envision a situation where you start at 20 and then the next order it's 40 and then the next order it's 60. I think you could compound it if somebody is really not returning to compliance.
Okay, thanks. And so that answer sort of begs another question. So you mentioned that that's the negotiated approach that staff took to the finding of pattern of violations. We as commissioners are sitting here as a judicial panel. And so we're not afforded that opportunity for the quote negotiation sort of thing. How does staff approach that in terms of its suggestions to us on the percentages, on the aggravation penalty, and on potential the corrective actions? How does staff think about that in terms of the job that we're being asked to do, which has sort of removed that negotiation piece, which is a prong that staff had available to it that we don't necessarily have?
I think it forms a starting point. I don't think you are obligated to impose 20%. I think you can go to the statutory cap. But yeah, we're in a different situation where you're acting as a judge and imposing it without being able to negotiate. And so, you know, when you get to that point, I think you can have discussions with staff, have discussions with KPK, but I think it's a starting point. That's why we're suggesting it, because it aligns with prior orders. But I don't think you're bound by it. The same with corrective actions. I think you have an operator in front of you that you can impose whichever corrective actions you think are appropriate. So I think it's a starting point. I don't think it's the end point, and you can have all the conversation and questions you want to get to the right result.
Okay. Other questions of this witness for commissioners? Ms. Stafford, did any of the questions afford you a need for any final redirect?
Thank you, Chair Robbins. I don't believe so.
Okay. All right, then let's move to your next witness. I would probably suggest, Ms. Stafford, that you try to keep all of your witnesses available throughout the pendency of this. The next witness, Mr. Axelsson, may speak to something that we may want to then speak to Mr. Farron about, and we've got that right. So hang with us, Mr. Farron, and all the other witnesses. Thank you very much.
Will do.
Thank you, Chair. We will ensure that all our witnesses are available for all of your questions. Next, we'd like to have Mr. Axelsson present to you.
Hello, Mr. Axelsson. Can you hear us?
Yes, I can.
Okay. Just as a reminder, Mr. Axelsson, you were previously sworn in as a witness, and that remains in play. We don't need to re-swear you. And with that, we can see your screen and we can see you, and you are, it's your turn. Go for it.
Thank you very much. Just making sure I can advance the slides. Good morning, commissioners. As mentioned, I'm John Axelsson, the East Environmental Supervisor for Cogcc. As I provide my presentation today, please feel free to let me know if you have any questions along the way. Today, I'm going to provide an overview of KPK environmental compliance issues related to their pattern of violations. In my presentation, I plan to discuss the following topics: the Rule 901A order and what led to the order, the severity of impacts specifically related to flowline releases, KPK's area of operations and the age of KPK equipment, examples of compliance problems, the lack of maintenance and active remediation sites, KPK's admitted lack of resources to timely clean up impacts, environmental impacts and intangible impacts. Last, I will discuss staff's requested relief, primarily surrounding some suggestions for possible corrective actions. Before I get into these topics, I want to begin by emphasizing the important aspects of two rules that are part of many rules cited in the pattern of violation. Please note that I'm talking about the previous versions of the rules in place at the time of the KPK violations. So Rule 906A, spills and releases. Operators shall immediately upon discovery control and contain all spills, releases of E&P waste, gas, or produced fluids to protect the environment, public health, safety and welfare, and wildlife resources. In this part, I would emphasize, operators shall investigate, clean up, and document impacts resulting from spills and releases as soon as practicable. So I think this rule is very clear. It tells the regulated community that if you have a spill or release, you need to control it and then clean it up as soon as you can. It does not allow operators to delay the cleanup for months or even years. It gives no relief from cleaning up a spill due to the time of the year, whether it's convenient to clean it up, or whether an operator has set enough budget aside to clean it up. Responsible operators are prepared to address spills and releases associated with their facilities. Based on the Rule 906A, the cleanup of a spill needs to be continually worked until it's cleaned up. In some cases, with very large impacts, there may be several steps to the cleanup. There will be the initial response and sometimes a straightforward removal of impacted material with some confirmation sampling that can be completed in a few weeks. In other cases, with impacts to groundwater or surface water, there may be additional steps of site characterization with multiple mobilizations to a site, followed by remedial design and installation, followed by operation and maintenance of the remedial system, combined with long-term monitoring. But even cases of those long-term remediation projects, the work should continue throughout the term of the project until successful completion. The rule doesn't allow for timeouts or breaks. And then we've already heard about Rule 324, big A, little a, pollution, but—
Mr. Chair?
Yeah, I was wondering this too. Mr. Axelsson, your slides have not moved. Are you moving through them, or do you?
Yeah, thank you. My opening is kind of long, and I'm not ready to get into the other slides yet.
And Mr. Messner, is that where you were going? Okay. All right. That's fine. And you can, however you desire. We just wanted to make sure that what's happening on the screen is consistent with what your approach was. I
appreciate that. Thank you. I should have mentioned I was going to be on this slide for a little bit.
Okay, go ahead.
Yeah, so Rule 324, big A, little a, pollution. And just want to emphasize parts of this. The operator shall take precautions to prevent significant adverse environmental impacts to air, water, soil, or biological resources to the extent necessary to protect public health, safety, welfare, including the environment and wildlife resources. And then importantly, it goes on to the requirement of operators to prevent the unauthorized discharge or disposal of oil, gas, E&P waste, chemical substances, and so on. So when an operator has an unauthorized discharge of produced fluids or gas to the environment, in the case of KPK, most commonly from failing flow lines, it constitutes pollution under our rules. If an operator fails to clean up the impacts related to the unauthorized discharge, it constitutes ongoing violation of the rule. And I think it'll be obvious as I present why I've emphasized these two rules. So now I'm going to get into the spills. So I would like to get into the Rule 901A order that was issued by Director Murphy to KPK on April 12th of this year. To begin, you need to have an understanding of what led up to that order. You will note that this slide was prepared over 2 months ago to submit for the hearing, so the numbers are not up to date as KPK has continued to have frequent spills.
Mr. Chairman, if I may, I must object. I believe that we're allowed to consider, based on your ruling last week, factors underlying the 901A order. Spills since the order was issued are not within the scope of that. Am I missing something? 9 of these spills have been reported since issuing the 901A order. That's the first indented bullet on this slide. I believe we have a problem with this exhibit and I object.
Ms. Stafford?
Thank you, Chair Robbins. This particular exhibit does contain information that's relevant to KPK's history of violations as set forth by the CMO in last week's hearing. We updated this particular exhibit in an effort to comply with the Commission's ruling there, and we apologize for any oversight that we might have made specifically with this indented line. I will take responsibility there that I missed that as I was reviewing the pertinent information, but we can certainly redact that line. I believe that might be the only thing that's outstanding.
Very good. Consider the line non-existent. Go ahead, Mr. Axelsson.
Thank you. Since January 1, 2015, KPK had 94 reported spills statewide. 89 of those spills were located in the greater Wattenberg area. If you'll note the chart, KPK spill count by year, you can see a significant increase in spills really beginning in 2018 to 2019, then nearly doubling from 16 spills in 2019 to 30 spills in 2020. The last bullet point on this slide is very important. 67 of the 89 spills reported in the greater Wattenberg area are related to flow line failures. The reason that's so important is because flow line failures often account for the most significant environmental impacts. That's because in Colorado, most flow line systems are buried and you can't identify the release until either it daylights to the surface or there is a significant enough pressure drop on a line that is actively monitored to alert the operator of a problem. In some cases, the operator may also identify changes in production that alert them to a problem. These releases can go on undetected for weeks, sometimes months, and in cases, even years. Flow lines, buried or partially buried vessels, and even above ground storage tanks that are leaking from the base can have similar impacts. So what happens when a flow line fails in the subsurface is that the produced fluids immediately start to migrate into the surrounding material. Most commonly, these releases that I'm describing take place in the vadose or unsaturated zone. The rate of migration is dependent upon the permeability of the surrounding material, which is the overall connected pore space in that media. We also often see significant migration along the path of the flow line itself because the excavation for the pipe is not always compacted consistently with the surrounding native material. So you have the surrounding dirt absorbing as much of the fluid as it can take, just like a dry sponge. If you hold it under a running faucet, it will absorb most of the water coming into it until that available pore space is filled up. Once saturated, that sponge can't take any more water, and you'll start to see water bubbling up or mounding on the surface of the sponge. The same basic things happens with the flow line release if it's not stopped at some point when the surrounding material is saturated and those produced fluids have nowhere else to go. They start migrating up. Gravity wants to cause the liquids to migrate downward from the point of release, but when saturation occurs, the fluids will eventually daylight. This generally takes a very large volume of released fluids to work up to the surface. Once on the surface, the fluids will often begin to flow. If we're lucky, somebody notices the fluids as soon as they reach the surface, but in many cases, depending on the location of the release, that fluid remains undiscovered for some period of time, causing further impacts on the surface to topsoil and other receptors that migrating fluids might reach. When you see produced fluids accumulating above a flow line, you're really seeing the tip of the iceberg, so to speak. Even a few gallons pooling on the surface can represent hundreds or even thousands of gallons released subsurface before the fluid's daylighted. When you have these flow lines located in sensitive areas with shallow groundwater, we often find that groundwater was impacted. As you've probably already noted, based on pictures of the resulting excavations at these sites during cleanup, it's quite common to find hundreds, if not thousands, of cubic yards of material contaminated from these releases. KPK continues to experience frequent flow line releases, resulting in large quantities of oily waste, lost topsoil, impacted groundwater. You should also note that KPK has provided testimony on some of the individual releases that the production is low, that some of these lines carry small volumes of fluids and have low operating pressures. And this may be counterintuitive to you, but releases from these types of lines can be the most impactful. These releases can go on for extended periods of time in the subsurface before the saturation takes place and the fluids are driven to the surface. Just like the sponge analogy again, if you barely turn on the faucet and allow water at a very low flow rate to migrate into the sponge, it'll take some time before it's saturated. If you blast the sponge with water, it becomes saturated almost immediately. So we often see that high pressure, high volume flow lines, again, depending on surrounding lithology, often migrate to the surface much faster and are detected sooner. Of course, in reality, neither type of a subsurface flow line release is good. So forgive me for the lesson on flow line spills, but I think it's important to understand the risk associated with these types of releases and the significant impacts to the environment. I didn't even get into the gas phase of a flow line release, which also causes an impact to air, can leave residual plumes of soil gas, and can be a significant safety threat, as we noted at the site referred to as the near miss incident. Luckily, that uncontrolled release of natural gas for several days from the 10-inch flow line with 20 to 40 pounds of pressure didn't ignite and seriously injure or kill a member of the public passing by on the adjacent county road. As a regulator, I really dislike when an operator has to depend on luck. So this shows KPK spills versus other operators. Presents a comparison of the number of spills KPK has reported in 2020 compared to 6 other companies of similar size who operate between 1,000 and 2,000 wells in the state. As you can see, KPK had over twice the spills at 30 compared to the next highest at 15. The overall average for other operators was 6 reported spills during the year. And I just want to ask you, why do you think KPK is seeing such a large number of flow line failures? Staff believes the primary factor is simply the age of KPK's flow lines and lack of maintenance or replacement when needed. Many of these wells were drilled in the 1970s, and all equipment has a practical operational life. Over time, steel pipe can corrode, leading to integrity failure. And I want to remind you of what corrosion really is, because it's an important term. It's the gradual destruction of materials by chemical and/or electrochemical reaction with their environment. So from day one, as soon as that pipe is installed and buried and starts to convey fluids and gas, it's starting to degrade. Now, it may be wrapped or coated with a protective layer, or there may be cathodic protection installed, but it will generally become less reliable over time. Even the older fiberglass flow lines that we see at KPK sites are more resistant to corrosion, but they are structurally less sound. So they can fail due to differential settling in the excavation, causing cracks or sometimes breaks. And if they were nicked or damaged during installation or repairs, those weak spots often fail over time. Just like all other equipment, pipe has a manufacturer recommended life. They don't last forever, and they shouldn't continue to be used if they are past the recommended period of time. If you think about KPK's flow line infrastructure, the individual flow lines coming from the wells to the separators at individual production facilities or to the consolidation lines where they have centralized production, they're often 30 or even 40 years old. Unfortunately, these flow lines aren't getting any younger, and flow lines don't self-heal. Based on the trend of the spill frequency over the past 3 years, strongly believe we're going to see flow line failures continue to escalate over time if KPK continues to operate as they have. I should mention also that reacting to a failed flow line and lining it with polypipe for a small segment, to me, does not really constitute an upgrade of the flow line system. And I'll get into that a little more later. So why did Cogcc issue the 901A order for the 29 spill locations? The primary reasons are listed on the slide and that you can read, but I want to emphasize the second bullet point. KPK's common practice has been to respond to the release and stop it. That's good. They then remove enough material to expose the flow line for repair, make the repair, then when approved by Cogcc, return the well to production. Over and over again, their priority is production over the environmental impacts and the impacts to the surface owners who own the property. After slapping up some orange construction fence around the excavation, if they even bothered to do that, there was no timely return to perform remediation, no attempt to comply with Rule 906A, no urgency or continuous work to remediate impacts resulting in ongoing violations of pollution. This potentially allows residual impacts to continue to migrate, causing more soil to be impacted and threatening or impacting groundwater. So the basic premise of this order was to cause KPK to completely remediate the sites, not just repair the flow line, before they could resume production. The importance of the order will further be illustrated on the next slide. So this map shows the 29 spill locations subject to the order. And I don't know how good the resolution is, but if you look close, you can see the town names near the spills: Frederick, Firestone, Dacono, Fort Lupton, and Brighton, to name a few. While many of the spills are in very rural areas, some of them are also located in residential and commercial areas. The Facility 4 North spill, both of them, are located directly across the street from Frederick High School. Another example that you're familiar with, the Grand Tank Battery, is located between an elementary school and a residential area. But even the more rural locations don't make the impacts or threat of impacts less. Many of these old flow lines run next to irrigation canals, creeks, mapped wetlands, sensitive wildlife habitat, water wells, and throughout many of these areas, we find very shallow groundwater, often less than 25 feet below ground surface. Many of the wells that KPK operates subject to the order were originally in agricultural fields or undeveloped properties. It's through no fault of theirs that many of these areas have been developed as residential and commercial property, but it's the worst kind of nexus, in my opinion, as a regulator who is charged with protecting public safety and the environment. This nexus between aging and frequently failing oil and gas infrastructure and developed communities is a real threat and was another important factor in issuing this order. On this slide, we have some examples of spill locations subject to the order and common compliance issues. Starting top left, you see the Paul Hines flow line release. Note the failure to properly fence the excavation and the condition of the fencing. Note the excavation with free product, which requires removal within 24 hours. The failure to remove presents an ongoing threat to wildlife and continues to migrate into the subsurface, causing additional impacts to soil and potentially groundwater. The top middle picture is of the Costlet A9 flow line, with another example of an excavation with inadequate fencing and failure to provide follow-up and maintain the site. And I'll get into the Costlet a little bit more later. Top right is of the Hewitt consolidation line release. Here the spill occurred in September of 2020. Work didn't start until February of 21. This excavation is now full of water. There haven't been stormwater controls installed, and it's located adjacent to a residence, County Road 8, an irrigation ditch, and a driveway. Note the house pictured in the background. Bottom left is the James S. Haley trustee flow line failure. After the spill was reported, KPK started some of the source removal by scraping up the soil shown in the picture. On one of our follow-up inspections, we noticed a new expression of fluids at the surface. We still don't know if the line wasn't properly isolated again, or if there was enough saturated material in the subsurface that fluids were able to wick up after the initial scraping of the contaminated material. This site is close to a commercial business you can see in the background. Bottom middle photo shows the Robert Birch #2 flow line failure adjacent to an irrigation canal. In this case, KPK failed to even notify the ditch company prior to digging in their right-of-way. You can see the wall of the canal eventually collapsed, and stockpiled oily waste was placed adjacent to the canal with no stormwater controls. These are serious issues. The site has since been backfilled and the ditch reconstructed, but still no surface reclamation completed, still no groundwater characterization performed. KPK has reported that they haven't been able to proceed with installation of monitor wells due to irrigation at the site, although we've yet to see any active irrigation there that would prevent them from performing the groundwater characterization. And last, on the bottom right, you see the Hodrick #2 flow line spill. As I described when discussing flow line releases that daylight to surface, here you're seeing the tip of the iceberg. This was also an area holding livestock. No fencing was installed to try to keep the livestock out of that area. And if you can imagine, there's a total of 29 of these locations out there subject to the order. So in each one of these photos, the location is private surface where the landowners are being impacted by KPK's lack of responsiveness and inability to timely remediate. Again, think about the basic rules I talked about at the beginning. Progress made since Rule 901A, suspension of operations. So this is another slide with numbers that are accurate to about 2 months ago, except I did verify that there still has only been 2 of the 29 sites subject to the order to achieve closure. And again, that order was issued on April 12th. And I believe that number is consistent with the information provided by KPK in their Exhibit 15. To be fair to KPK, they have made more progress on these projects than I've seen in the past, and it has been due to the order. With that said, staff is generally not satisfied with the overall progress. To only have received closure on 2 of 29 locations in 5 months is not timely remediation. So they are close to achieving closure on a handful of additional sites, but have not made any progress on several more. And I'll get into that a little more in an upcoming slide. KPK documentation often has many errors or is incomplete. While staff has strongly suggested to them to get a qualified full-service consultant that could take their backlog of impacted sites and take over the preparation of work plans, scheduling and performance of site characterization, remediation, and reporting, KPK chooses to continue to try to self-perform as much of the work as possible. It is true that they've utilized Mr. Haddle of Apex Consulting to help them with some of the delineation work, and staff is glad that they're utilizing his services. However, they need additional help to timely remediate these sites. I'd also mention that KPK asserts that it has been delayed because they've had to clean up historic impacts from other operators. However, at no time has KPK provided evidence that the historic impacts were caused by a predecessor operator. What is likely that at many of these sites, KPK has been the operator of record for over 30 years. They're likely to have been the responsible party for the historic impact. This slide depicts the Counsel at A9 flowline spill excavation with varying amounts of free product during 7 site visits by Cogcc between December 2020 and July 2021. Staff required a corrective action to remove free product within 24 hours during the February site inspection, and on each return visit, product was still present. This is a serious issue. It represents an ongoing threat to wildlife, continues to cause migration of contaminants into the subsurface, further impacting soil and groundwater. In this case, KPK claimed that another operator would not allow them to access the site. We assume that if KPK owns a flow line in this excavation, that they would be able to access and remove the product. This slide is also illustrative of the ongoing lack of follow-up and maintenance that KPK generally performs at these locations. There isn't a specific rule that requires this, but it's just common sense. If you have a contaminated site with an open excavation, you need to be checking on it daily and updating the impacted surface owner frequently and maintaining fencing and stormwater controls. You don't just leave it sitting unattended for weeks or months or years in some cases at a time. Again, the numbers on this slide need to be updated, but they're close. There has been no remedial progress on 6 of the sites. 19 have open excavations. 6 still have stockpiled waste on site. And we're still documenting 7 locations with inadequate fencing. The picture shows another view of the Hewitt consolidation release. As with many of the KPK spill locations, this one is in close proximity to the public road and a private residence. The failure to timely remediate causes the surface owner potential inability to use their land. This slide shows excerpts from 2 Form 27s that KPK recently provided as quarterly updates for locations subject to the order. Current Rule 913D requires operators to provide a specific implementation schedule to complete investigation and remediation. As I've stated, they must investigate impacts to soil, groundwater, and surface water and clean up sites as soon as the impacts are discovered. Operators are required to request changes from the schedule at least 14 days in advance. In these examples, KPK doesn't even attempt to provide a schedule. They simply state that they don't have resources and work will begin as soon as crews become available. This rule was passed for a reason, to keep operators on a formal schedule to continue to remediate contaminated sites. Related Rule 913E requires operators to provide this quarterly update to document progress of the site investigation and remediation. These 2 examples illustrate a serious ongoing problem with KPK and their inability to make progress cleaning up their spills. They're experiencing flowline failures and creating significant impacts to the environment at a pace they can't keep up with. In case the slide isn't clear, I just want to read parts of each update. For the Lawrence Totem consolidation line, no impacted soil has been removed. Work will begin as soon as crews become available. That's not acceptable. For the facility number 8 consolidation flow line failure, work will commence on this project once resources become available. Again, that's not acceptable. Cogcc has received 13 similar updates like this for remediation projects from KPK. Not aware of any other operator who has given us a similar update.
Mr. Axelsson, can I ask a question before you move on?
Yes, go ahead.
Under the facility number 8 consolidation flow line slide, there is, KPK has mentions that is devoting internally and third-party resources on remediations that have been designated high priority by KPK staff and conversations with Cogcc personnel. Can you speak to conversation? I mean, the implication there is like this has been okayed by staff, that they are, going at the high priority ones first, and these lower priority ones are going, later. Can you speak to whether that implication is accurate or not? Has staff sanctioned this approach? Because your testimony earlier was you have not sanctioned sort of a delay approach for low priority ones.
Yes, that's a very good question. And staff has not sanctioned or given them any type of verbal variance to our rules. I do believe what they're referring to was a meeting that was held between myself, KPK staff, and Mr. Jacobs attended, where at the end of the meeting, they asked for guidance. And I was trying to be helpful, and I told them the first 10 or 15 sites on the order are very important. You really do need to get moving. But at no time did I say, you can just tell us you're not working on any of the other sites. So there's been no priority that staff has tried to set that would exclude them from complying with our basic rules to clean these sites up immediately.
Okay, thank you. You can proceed.
Okay, thank you. So just a couple of examples of some of the sampling that's been done at the KPK sites. Part of an environmental protection specialist's duties include witnessing, sampling, and sometimes collecting soil and groundwater samples to verify and compare with data received from operators. It's basically the old trust but verify approach. For the sites subject to the order, Cogcc asked KPK to provide notice prior to final confirmation sampling and backfill. This gives us a chance to observe and in some cases collect our own samples. KPK notified us that the Paul Hines Flowline spill had been cleaned up and they were ready to collect final confirmation samples. When we arrived and inspected the excavation, there were what we believe to be obvious indications of remaining impacts. Due to our presence there that day, excavation is ongoing at this location. This is also an example of why KPK needs the help of qualified people to perform or at least oversee this kind of work. And I think if this was a one-off, it would be less concerning. But this was another site subject to the order where KPK performed, in this case, final confirmation sampling without giving us any notice. Based on the results they submitted that indicated all samples were in compliance with Table 915-1 soil concentrations, the environmental protection specialist had approved backfill of the excavation. Before they started backfill, we had an environmental protection specialist inspect the excavation before they could get started. And they observed what they considered to be very obvious impacts of contamination remaining in place. Based on elevated field screening results, we collected soil samples and submitted to the lab. And those results verified exceedances to the cleanup levels for total petroleum hydrocarbons and several other volatile organic compounds. Where KPK inexplicably had results indicating no detection of TPH, two of COGCC samples contained 38,699 parts per million and 27,816 parts per million in another sample, far in exceedance of the 500 part per million cleanup standard. This cleanup's nowhere close to being finished, but they had submitted data to the contrary. These types of situations have eroded our trust with KPK, and we're having to spend as much staff time as we can to be present to observe sampling and backfilling. And so that's my last slide, but I do have a few more points to make, so I'm just gonna continue. Before I finish, I do want to talk a little bit about the impacts from KPK operations. During testimony for each of the locations, KPK's lawyer wrapped up their statements with discussion about the impacts or the lack thereof. Listening to them, you might think these sites really haven't caused much real or substantial impact, but that's false. In the best case, if one of these flow line releases only impacts the dirt surrounding the pipe and some topsoil, still represents a significant impact. As you've seen, many of these cleanup sites generate hundreds and even thousands of cubic yards of contaminated material. That's a real impact to the environment. And I know that you all understand that topsoil is a precious commodity, and it's very difficult to replace. Further, when KPK responds to these spills, there's often a much larger area of disturbance to access the site, resulting in more topsoil compaction and disturbance to areas that in many cases will need to be revegetated. Even if you have a good source of clean backfill, it seldom matches site materials. This can cause differential infiltration of stormwater. And even when there's good source of quality topsoil, it often doesn't match the same agronomic properties of the surrounding topsoil. On active agricultural lands, this can cause crop yields to be impacted and often results in the need for the addition of fertilizers and organic material to try to bring the productivity of the topsoil back, which can take years in some cases. In the worst case, when you have an impact to groundwater, as there is at many of these locations, there's already a significant impact. Cogcc has a memorandum of understanding with CDPHE Water Quality Control Division and is an implementing agency for their Regulation 41, the basic groundwater quality standards. It's our mission to protect groundwater. It's another precious commodity. The well integrity rules, the pit lining rules, production facility lining rules, the strengthened flow line rules, and many of the 900 series environmental impact prevention rules all help to provide protection of groundwater in Colorado if they're followed. But even in this comprehensive framework of regulations, it can't protect the environment from the operation of aged flow lines that fail on a frequent basis. As you know, when groundwater is contaminated, it's very difficult and expensive to clean up. So these impacts are very real and cause serious harm to the environment. These are only the environmental impacts. The intangible impacts include the very real alienation of too many surface owners to count who have been impacted by KPK operations. Unfortunately, many of the people that I have to talk to, it causes them to believe that all oil and gas operators act in this way, and it destroys the reputation of the entire industry. And that's a shame because there are many excellent operators in the state of Colorado who go above and beyond Cogcc rules and really try to be leaders in the stewardship of the environment. So now I'm going to switch, and the last thing I'd like to talk about is the relief requested by staff and specific corrective actions. So in paragraph 4A through C of staff's pre-hearing statement, we ask for some specific timelines to make KPK finish remediation and characterization of groundwater where applicable, and also a requirement for KPK to use qualified individuals to perform and report this type of work. We still believe those are important steps to take, as 5 of the spill locations subject to this enforcement action are still unresolved. Beyond this relief, staff would like to suggest a possible compliance plan approach as part of any order created to resolve this enforcement action. And maybe KPK has already started on some of this, and I'm sure they'll tell us during their testimony if they have. But the environmental staff is less concerned with the size of the fine than we are with getting the sites remediated. And I'm not talking about only the sites subject to this enforcement matter, but all of the current remediation project that KPK has. They really need a qualified full-service environmental consulting firm to take over the management and execution of all of their remediation projects so they can get completed in a timely manner and the appropriate documentation is submitted. We also want to put a plan in place to help KPK prevent additional flow line failures. Staff believes that KPK as a company needs to make institutional changes. Instead of only reacting to spills, they need to get a qualified engineering firm with expertise in construction, maintenance, and operation of pipelines to perform a systematic evaluation of their entire flow line system and production facilities. This evaluation shouldn't be limited to only the age of the flow line and material of construction, but they should also assess the areas where the flow lines are operated. Are they in areas of known shallow groundwater? Are they in residential areas or next to schools or businesses? Are there bodies of surface water or wetlands that could potentially be impacted by a release? The operating record of these lines should also be evaluated. If there are previous failures along flow line segments, that should be a significant factor. Based on this review, they should create a written plan with a schedule to upgrade those segments of flow line that represent the greatest risk or are simply beyond the manufacturer's intended timeframe of operation. If the associated wells don't generate enough revenue to pay for these upgrades, then it's time to plug those wells out and properly close the associated facilities. Another outcome from this type of review should be a written maintenance, repair, and replacement plan that KPK adheres to, including appropriate record keeping. Emphasis on record keeping. Next, to prevent future violations such as those documented at the soil spread field, KPK should obtain help from a qualified company to develop a detailed waste management plan for all wastes generated by their operations. The plan should identify things such as the appropriate disposal methods, storage, transportation, final disposition of wastes, and again, record keeping. This should also include a training program for KPK employees tasked with waste management. Along these lines, staff also believes that KPK needs to implement a written training program for spill reporting. This should include training on all required reporting to Cogcc and other agencies, depending on the type of spill. And these are meant as constructive suggestions for possible solutions to improve KPK's overall compliance and hopefully minimize the environmental impacts being caused by their operations. And that ends my presentation, so thank you very much for your time.
Thank you, Mr. Axelsson, for the direct testimony. We are at a spot in which our agenda calls for a 10-minute break. So before we move to cross-examination, redirecting commissioner questions, we're going to take 10 minutes. It is 11:13. Let's return at 11:23.
Mr. Chair, I think you're muted.
Hold on just a sec. Can you hear me now? Okay. Sorry about that. We are back on the record. We now are, we'll give Mr. Jacobs or his co-counsel the opportunity for cross-examination of Mr. Axelsson.
Thank you, Mr. Chair. Good morning, Mr. Axelsson. Thanks for being available for some of my questions. First off, I'd like to ask you, you mentioned that a number of the slides that you presented were from Staff Exhibit 5, I believe, and had not been updated, that was prepared a couple of months ago. Is that correct?
That's correct, that I didn't update some of the statistics. We did delete some of the slides that pertain to spills after the order.
Thank you. And I do appreciate your acknowledgement that KPK's made progress in the interim in a couple of months since those slides were prepared. We've talked a lot about flow line integrity, but you're not in the flow line integrity unit, are you?
That's correct. I'm not.
And you also talked about not using materials beyond a recommended period of time. Are you aware of any recommended length of time that a fiberglass flow line should be used and then replaced?
I'd have to check ASTM standards off the top of my head. I don't.
But you're not aware as you testify here today, are you?
I do understand that there are manufacturer designated guidelines for the amount of time a material will last.
And KPK is not alleged to a violation of Cogcc rules for having used fiberglass flow lines longer than the manufacturer has recommended, has it?
No, sir.
Thank you. You talked about a number of spills in your slides, which, as we pointed out, do refer to some that aren't within the permissible scope of this hearing. But you also did not mention the cause of those spills. Have you examined how many KPK spills that you've discussed in your testimony today were caused by third-party activity?
I don't know the exact number. We are aware that some have been, and we have communicated with KPK about those.
So you're aware of line strikes and differential settling when line crossings don't compact the backfill properly and settle and crack the fiberglass line? You're aware of that?
We are aware of that. And in some cases, the operators who've struck those lines have told us that it's because KPK was not able to locate their lines before the start of their work.
How is excuse me, I'll withdraw that question, but it's a fact that many fiberglass flow lines are not specifically locatable because they're not ferrometallic and have not been recorded their locations. Isn't that correct?
No, it's not. You can run a line down a fiberglass flow line to locate it if you have to.
Thank you. You mentioned historic contamination and that KPK is concerned about it, as you might expect. Do you allow the operator KPK some time to gather evidence to engage in a forensic analysis for purposes of establishing whether a third-party operator is responsible for contamination, or is that not your concern?
You know, I think we do consider it on a site-by-site basis. And what we want to do, though, is make sure that the impacts that are real and current, and that the threats that are there are taken care of in a timely manner. If an operator wants to point a finger at a different operator, you know, we don't say, okay, you have 5 years to do that, just stop remediating.
Understood. Thank you for your answer. You also mentioned and discussed the causal at A9 location. Are you aware that the remediation work plan for that does provide for daily hydrovacking and that Mr. Chris Canfield approved that? I'm happy to share that with you if you'd like to see that.
Yes, I'm aware of that. I do believe some of that may have been done, but as the slides showed, we continue to see accumulations of product for months at that location.
And you also mentioned, you can see this highlighted area. This is where we propose free product back truck removal on page 3 of the form. And then Mr. Canfield's approved that on July 9th at the bottom. You see that?
Yes, I do.
And I'm going to stop share now. You also indicated that there was an access issue of which you were aware. This concerns the high pressure gathering lines in the photo you showed that went under KPK's line. Is that correct?
Yes.
And are you aware that they've not allowed KPK to excavate any further, which has halted progress on the site?
Again, that KPK has told us that. We have encouraged them to negotiate access if it's really being limited.
And we'll address that with our own client testimony. Thank you. Oh, okay. You're familiar with the Paul Hines #1 flow line location subject to the 901A order, are you not?
Yes,
And you've had email correspondence and meetings with KPK about a buried concrete vessel at that location discovered by KPK in the process of addressing historic contamination. Is that correct?
that is correct.
Is it not true that staff unilaterally changed the ownership record for that buried vessel to KPK from Amoco on July 14th, 2021 in the Cogcc database?
Objection. How is this relevant?
It goes to historic contamination and staff's alteration of records, our ability to understand who's responsible for historic contamination. Mr. Axelsson just talked about it. They don't specifically allow it, they do it on a case-by-case basis.
I believe I object to the characterization of alteration of records. That's a little outside.
I'll withdraw that, but they changed it to reflect KPK ownership from Amoco, did they not?
Go ahead, Mr. Axelsson, you can answer if you can.
Yes, we did update that record.
Excuse me, that's fine. That was the answer I wanted, and that was done by staff without KPK's prior knowledge or consent. Isn't that right?
Yeah, we quite commonly, if we find a facility that was permitted and was not transferred properly to the operator of record, we will update the record to the current operator.
And when KPK learned of this by reviewing ownership records on its own, it contested the unilateral change of ownership by staff being made without a corresponding Form 10 or other evidence of KPK ownership. Is that correct?
It is correct. And when we learned that it was incorrect, we updated it back to Amoco.
And I believe I'm going to share a screen very, very briefly again, that you're on a number of email chains. This is one of them. You're copied. It's to Mr. Canfield. And this is correspondence between Max Knopp and Mr. Canfield about ownership of the buried concrete vessel. Here's a screenshot. You can see that shows Amoco ownership of that vessel. And that's what was changed in July by staff unilaterally to KPK ownership, not even acknowledging that there was an intervening owner between Amoco and KPK. It would just switch to KPK. And then we have another email, Exhibit 20, that was Exhibit 19, regarding the concrete vault and the fact that it had been changed back now, as you indicated here, in just last week in mid-September. Is that correct?
Yes.
Thank you. And then lastly, you did confirm you're not in the flow line integrity unit, but Mr. Mclaren is, isn't he?
He is, but I have significant experience with the impacts related to flow line failures.
Sure, and in environmental, I expect you would. But are you aware that Mr. Mclaren has commented favorably in a number of his inspection reports on the upgrades to the locations of flow lines that have failed, upgrades performed by KPK? And I'll share a screen again briefly. There we go. Can you see this? This is Exhibit 4, KPK, field inspection form by Mr. Mclaren. You see that?
Yes.
And in this highlighted area, he talks about how we're through the bell hole excavations, exposing 6-inch off-location line. And we're running 400 feet of rolled 3-inch HDPE pipe that is being stung or slip lined inside the existing 6-inch carbon steel line. You see that?
Yes, sir.
And there's several other examples of that. This is the H. Hewitt location, I believe. There's also Exhibit 6, recurring similar comments from Mr. Mclaren regarding the John Wygant location. And also by Mr. Mclaren in our Exhibit 5. This is for the Uper 43 location as well. All documenting the repair of a single corrosion hole in some cases with hundreds of feet of HDPE pipe. You don't contest or deny these acknowledgments by Mr. Mclaren, do you?
No, I believe Mr. Mclaren is accurately documenting what's happening at the site, that these are repairs being made to a failed flow line.
Thank you. Just a moment while I check over my notes. Are you aware of whether, well, no, I'll withdraw that question. I think I'm done with cross-examination questions for this witness. Thank you.
Thank you, Mr. Jacobs. Ms. Stafford, any redirect?
Just a few questions, if I might.
Go ahead.
Mr. Axelsson, Counsel just asked you a few questions about access issues relating to certain KPK sites and how that affects their ability to perform work. Are you aware of how many of these sites have access issues?
Not specifically.
Oh, and we also heard some discussion about the situation involving the Paul Hines, the buried vessel at that site. Could you explain to the commissioners what happened there, what the situation was, and then what the resolution is as of now?
Sure. Yeah, so there's been 2 separate reported spills related to flow lines at the Paul Hines. As they were performing excavation to remediate impacted soils, they discovered on their lease a buried concrete vault. And at that time, they told us they were going to stop remediation because they didn't believe they should have to address the concrete vault and that there might be historic impacts related to it. Our position was that there was contamination from both of the spills in the same footprint that actually have migrated down to the top of the vault. And during a records review, one of our staff members found the old pit permit for the location. And I'll say in the mid-90s, Cogcc did quite a bit of work with KPK to make them replace a number of leaking concrete vaults. They actually prepared a list of the vaults. There were 14 vaults that they were going to remove. And I incorrectly thought that this was one of those vaults. As a result, we updated that facility record to KPK. When we did a more detailed review of their pit inventory and the vault inventory, and I learned that that vault was not included, we did change the record back.
Thank you, Mr. Axelsson. I don't believe I have any further questions this time.
Okay, thank you, Ms. Stafford. Thank you, Mr. Axelsson. Mr. Axelsson, I'll ask an initial question from commissioners. It's not as much a question as maybe a ask or a request, but you concluded your testimony with an outline of staff's suggested corrective actions, including a suggested compliance plan with a lot of different components. I would personally, not that I'm going there, but I'm trying to gather all the information to have an informed decision at the end of all this. I would love to see that in writing, to see all of that information that you testified to. I tried to quickly put it into my notes, but I know I missed some stuff. But if staff could gather that information and deliver it as I don't know, Ms. Larson, a document that would be e-filed, and then it goes to everybody, so Mr. Jacobs and his clients would get it as well. That's a request that I would like to make of staff, and the sooner we could get that, the better for our consideration on all this. Is that something that's doable?
Certainly, yeah, I can provide an outline of that information as soon as I get a chance to, yes.
Okay, thank you. Other questions from commissioners for Mr. Axelsson? All right, I see Commissioner Nanjapa and then Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Mr. Axelsson, for your presentation and the information that you shared. You mentioned about, as part of, I think, the same matters that Chair Robbins was just talking about a qualified engineering firm coming in and kind of evaluating the flow lines and et cetera. Do you know, is it possible that some of these small fiberglass line leaks may not still be detected in our own integrity testing requirements, or even with a professional firm doing that? And well, I'll start there, and then I have a second part question.
Yes, I would agree with you that, again, our rules are effective, but we don't have daily pressure monitoring of most lines. Some operators do, but if you have an annual pressure test on a flow line and it passes, you have 364 days more until the next one. So that's why in my testimony I suggested, them evaluating the age of materials, past operating history of failures. They could be much more proactive, even just doing more, I don't know if they do any at all, but audio visual inspections along their flow line paths. So yeah, there are things that other companies do that would help detect and prevent these type of failures.
Okay, thank you, Mr. Axelsson. And that was my next question: are there other ways, for example, walking along where a flow line is thought to be buried, and so obviously the visual, if there was daylighted material, but is there another way to detect a spill that might be subsurface that has not yet daylighted, other than soil sampling?
The best way to see that would be, a requirement for real-time pressure monitoring of flow lines. So then you would see pressure drop across the line, and potentially that might mean there's a release subsurface. It could mean there's a problem at a connection or a valve. And it's difficult because they are subsurface. A lot of communities that provide water services that have subsurface water line breaks, they use an audio devices basically or acoustic devices to listen for spills. They can perform inspections that way. And walking your flow line path regularly. Some companies are doing that with drones and things now. But yeah, personally as an EPS, I've found several spills in the field during my career here just by walking flow lines to the production facility.
Are there other sort of signature traits prior to daylighting, depressions in the soil, or I think we heard in prior testimony like dead grass, or that type of thing? What are some of the visual, you kind of mentioned it with this specific, the audio testing, and I was kind of wondering about these different things, what are other ways that these types of spills can be detected before they are daylighted? So are there other sort of visual signs and things that you might look for?
Sure, yeah, and your examples were on the mark. So you can sometimes have subsidence above where a flow line fails, and that we see them a lot on flow line crossings at drainages that become saturated, and over time there's some subsidence. So even before the line fails, sometimes you can, if you're paying attention, you could see some subsidence that might have impacted that line. And then the fluids themselves sometimes can cause the material to settle above where the flow line has failed. And if there is a gas release, certainly, natural gas, methane will kill the root zone of plants. So that's one thing we look for. I wouldn't say we get a number of them, but we do get complaints each year where, farmers will say, hey, I've got a circle in my crops that just won't grow, and it was fine last year. And so we'll ask the operator to perform a soil gas survey. Lo and behold, yep, there's methane in the soil that has caused death of the root zone, basically. So those are some other methods that can be used.
Okay, thank you. And then last question, in your testimony, you had talked about some of the groundwater sampling, that there were some underway, but several sites that hadn't yet begun. These are the sites in the 901A order. And I think you mentioned that there were some that were located in close proximity to excavation sites. And I just wanted to get some clarity on, was that a problem, or were there, was it insufficient numbers of groundwater monitoring wells, or maybe I just misunderstood altogether, but I thought there was a point in your presentation that said that there were some sites that were close to excavation, and at least I sort of took away an implication that that was improper.
And I'm sorry if it wasn't clear. I guess the best way to answer that is just coming up to the order before it was issued. We did have a number of sites where they had excavations where we believed groundwater had actually infiltrated into the excavation. And we were trying to get them to start characterization of groundwater, which usually starts with at least the installation of one monitor well near the source. And if it's obviously groundwater and it's been impacted, then you need an array of monitor wells to both characterize the flow direction of the groundwater so that you can appropriately establish point of compliance wells. And we weren't really having success getting KPK to do any of this type of work. Since then, with their help from Mr. Haddle, they have been doing more groundwater characterization. But I do believe several of the sites, it just still hasn't been accomplished yet. And you need to have that network of monitoring wells in there to determine which way groundwater is going and if there's other receptors at risk until you know that information.
Okay, thank you. And so, and just to make sure that I'm clear, then it wasn't that there was a problem with the groundwater monitoring wells that had been installed, just that there had not been sufficient groundwater characterization done yet at some of the sites. Is that correct?
That is correct. And in some cases, though, we're not getting like the monitor well construction logs from KPK. So we're still trying to get them up to speed with some of the documentation. So I can't say that the monitor wells that were installed are appropriate.
Okay, thank you.
Commissioner Gonzalez.
Thank you, Chair. Thank you, Mr. Axelsson. Appreciate the presentation today. I've got a question based on some of your testimony that I'm going to go back to my question on certificates of clearance that Mr. Farron kind of punted your way. Of the 89 spills that you referenced since 2015, how many of those spills were reported correctly and how many were not and then resulted in NOAVs for either reporting or otherwise non-compliance of corrective action?
That's a really good question, and I'd have to look up some statistics on that. I don't know off the top of my head, but I would say a lot of them were properly reported. I do want to clarify, though, that staff, it's never been the practice of the commission to just issue an NOAV for a spill. So in most cases, when a spill happens, if the operator reports it properly and then begins with appropriate remediation, there's never any enforcement involved. There is a caveat to that. If there's a surface water impact, we often go straight to an NOAV in that situation and coordinate with Water Quality Control Division. So like these enforcement issues that we've been discussing are because there really wasn't appropriate reporting, and some of them were follow-up. And that's what led to the violation after, weeks or months after the original release.
Sure, and thank you. And I don't know if there's a way for you to pull that information together, but I think it would be impactful for me to kind of understand, hey, even if an NOAV was not issued here, what what was the practice that occurred, right? You know, we're talking about a pattern. Is it something that looks like what we heard a few weeks back or last month from the Nesu wells, or is it more a function of, you know, hey, these were done and we moved on? So that's what I'd like to find out. So I don't know if that's appropriate for you to come back and give us some information on, but that'd be impactful to me in considering patterns here.
Yeah,
Go ahead.
yeah, I can try to get some help from staff to provide some of that data.
That'd be helpful. Thank you. My next question is following up on the question I had from Mr. Farron about certificates of clearance. And I'm really just trying to understand the impact of the relief sought here. And so I'd like to understand, again, Mr. Farron said that there would be no impact on an operator's ability to engage in the corrective actions, or specifically KPK's ability to engage in the corrective actions a part of this matter by having their certificates of clearance suspended. And I'm still trying to understand if that's the case, because I've heard otherwise, and I'm just curious what your opinion is on that, Mr. Axelsson, on would there be any limitations on an operator, specifically KPK, being able to fulfill their corrective actions with a suspended certificate of clearance?
No, I don't believe so. I mean, they wouldn't be able to sell product, but it wouldn't limit, you know, physical cleanup of the site. It would limit their financial ability. And that was part of the point of the 901A order, was to say, you know, you need to stop production at the wells responsible, get the site completely remediated, and then you can go back to production. So we hoped that that would give them incentive to get them cleaned up quick so they could go back to production and generate that revenue again.
Let me ask you a more specific question on that, because that's consistent with what we heard from Mr. Farron. But in terms of selling the product, you know, what does an operator do if they're producing gas and that gas is going, you know, from the separator into a gathering line? I mean, can they do that? Can they remove gas without selling it?
In that situation, no, they'd have to shut in the line, because once it went through the meter, and it basically at that point is sold and changes custody. And that's what eliminating the certificates of clearance would do. It stop them from selling that gas.
And there's no operations associated with the corrective action that would then, I guess, require them from a safety perspective to produce gas to clear the line, or to do anything to service what they need to take under that corrective action?
Not that I'm aware of.
Okay. Thank you, Mr. Axelsson. Appreciate it.
Other questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair, and thank you for the testimony, Mr. Axelsson. I wonder if we could talk just a little bit about timing, and I'm trying to understand a little bit about existing operations and corrective actions, and perhaps some things moving forward. So in your opinion, between the time that the 901A order was issued, as well as the now confirmed NOAVs, has there been adequate time between that point and today for all the corrective actions to have been completed?
Yeah, it's my opinion that at least the soil impacts at most of these sites could have been excavated and removed if that was their choice of remediation. It does take more time when there's groundwater impacts, but I do think they could have made a lot more progress in the overall amount of characterization to groundwater and trying to get those monitoring networks in place.
So short of the continued groundwater sampling, a significant portion of these corrective actions or remediations could have been accomplished between April and September. Is that correct?
Absolutely. I mean, we hoped that the order would prompt them to take this extremely seriously and really proceed. Everything's based on resources. I don't know if they don't have the resources or don't want to spend money to clean the sites up, but they haven't done it.
That's good to understand. Now, from today moving forward, understanding what the situation is on the ground right now, what, in your opinion, is a realistic time frame for accomplishing the corrective actions from both the confirmed NOAVs as well as the associated issues in the 901A order? Is it 1 month? Is it 90 days? Is it 6 months? Understanding that some of the groundwater sampling, extends beyond what immediate action or remediation may need to occur.
Yeah, so we suggested 90 days for the existing NOAV sites, and that was to finish remediation of soil impacts and finish delineation of groundwater impacts. So there's 5 of those sites that are still outstanding. To be realistic with the additional sites, I do think like a 4 to 6 month time frame might be reasonable, but again, it's the amount of resources that they put towards it. I mean, you could complete it much faster than that, and other companies we work with, do respond quickly and get other qualified consultants online to do the work.
So if resources were not an issue, or if you had the resources available to be able to address everything concurrently, this could get done within that 90-day time frame, realistically?
It's possible. It would take a lot of resources, and it doesn't mean that the groundwater contamination would be completely remediated. I'm just kind of talking about a benchmark of getting the actual delineation complete so that they have an appropriate monitoring network in place.
Okay, thank you, Mr. Axelsson.
Further questions from commissioners? Okay, I'm not seeing any further questions. Mr. Axelsson, appreciate your testimony.
Chairman, if I may, just one quick follow-up question.
Okay.
Thank you. Mr. Axelsson, sorry to detain you further. Just one quick question. Were you aware that staff performed a flowline integrity audit of KPK's flow lines in 2020 that was led by Mark Schlagenhaupt and that they passed?
I was aware of a records audit. Yes.
Thank you. No further questions. Thank you, Mr. Chairman.
You're welcome, Mr. Jacobs. Mr. Axelsson, I was going to say that, again, we thank you for your testimony, and we look forward to getting your 2 homework assignments.
Okay.
And if you could get the information requested by the commission, and maybe we'll call you back orally for that. And then if you could get the information that you testified to and get that allocated down into a written form that could be then filed so that all the parties have access to it, that would really be appreciated as well. Ms. Stafford, I see that you're unmuted. Did you want to add anything to any of this, or do you have other questions?
Chair Robbins, I was just hoping to ask for clarification on Commissioner Gonzalez's homework assignment, just to make sure that I understood it clearly.
Go ahead.
Commissioner Gonzalez, could you speak a little bit more about the specific information you'd like us to comply, Mr. Axelsson, to compile, excuse me?
Sure. So in Mr. Axelson's testimony, he brought up 89 spills since 2015, and we're here to establish and to understand a pattern of violations, or to evaluate a pattern of violations. And so, since that information was brought up by Mr. Axelsson, I think it's important that it be supported with actual violations or a pattern associated with those 89 spills. So I'm curious how that each of those 89 spills and It could be bucketed or could be, categorized in terms of response or in terms of any potential violations or in terms of action or inaction for corrective actions. That makes sense?
It does. Thank you for clarifying that. I appreciate it.
Sure.
Mr. Chairman, a point of order on that, if I may.
Go ahead.
You'll recall that I objected to slide 2 of Mr. Axelsson's presentation on the basis that spills subsequent to the 901A order, which are outside the scope determined by this commission for consideration, not be included. And to the extent Commissioner Gonzalez's request for information on 89 spills extends to such spills, it should be 89 minus X for the homework, I believe.
Mr. Gonzalez, do you want to clarify given that point?
That's fine with me, right? I mean, I think that the 89 spills are outside of NOAVs and OFVs as it is, but I think it's important for us to know just so we can take in that information in the appropriate scope.
Thank you.
Okay, Ms. Stafford, clear?
Clear. Thank you.
Commissioner Nanjapa, question?
Yes, Mr. Chair, thank you. Sorry, I just wanted to get clarification on the last question that Mr. Jacobs asked with respect to the Flowline integrity audit. And then Mr. Axelsson, you responded that you were aware of a records audit. And so could we get some clarity on whether there was actually an integrity audit versus some just tracking of locating the flow lines or something like that?
Yes, my understanding was it was a review of KPK's flow line submittals that respond to our rules. So for basic integrity annual checks. So the audit, it didn't do any physical, testing of their flow lines. It doesn't mean that their flow lines all have integrity right now, but yeah, their records did seem to be in order.
Okay, thank you very much.
You're welcome.
Okay, anything further from anyone with regard to this witness? Mr. Axelsson, thank you so much for your patience and your professionalism in answering lots of questions. Okay, with that, we'll let you go do your homework and we'll look forward to talking to you again perhaps later today. And with that, Ms. Stafford, your next witness.
Thank you, Chair Robbins. We would like to have Director Murphy appear and provide us with her presentation.
Was she? Yeah, I'll check her.
Yeah, I'm nearly positive.
Good.
I believe Director Murphy was sworn in at the beginning of this hearing.
We were just questioning ourselves about that as well. Ms. Murphy, were you sworn in earlier?
I was, Chair. Thank you for the question.
Well, consider yourself still sworn, and we look forward to hearing from you.
Thank you, Chair. Thank you, Commissioners. For better or worse, my remarks are very brief and do not have the benefit of a PowerPoint presentation, so I don't have to ask 32 times if you can see my slides advancing. So I think that's good news for everybody. I wanted to talk a little bit about why we're here. I think it's really important that at times staff elevates to this commission the breadth of the situations that are presented in a situation like this by these specific NOAVs. You were the 5 people charged with administering this act, and staff is acting on your behest very often. And at times I think it's appropriate to bring forward something to you. And especially in circumstances as has been made clear by Mr. Axelsson's testimony, more impacts means more resources to managing ongoing operations, as well as addressing those types of impacts from an operator's oil and gas activities. Some sort of implication that staff should be in charge of prioritizing or directing the order in which cleanup is performed seems beyond the scope of what staff should be doing. It's our expectation that operators, when there is a spill, comply with the rules to report them and clean them up. We expect that to occur in both a professional and timely manner. There are risks that come with operating oil and gas wells, And for the most part in Colorado, we don't see challenges with cleaning things up. But operators must be prepared to and able to respond to these situations. Our inspectors and environmental protection specialists verify that work is performed in accordance with the rules and act, but it's not our responsibility to direct how a company is staffed or how it is organized or how it responds in situations such as this. More importantly, we're here today to pursue these NOAVs for your consideration because KPK hasn't responded to the regulatory requirements, hasn't responded to the staff requests. There are ongoing corrective actions that are reflected in each of these underlying NOAVs, and it has required staff to consistently re-inspect sites, the same sites, for ongoing unremediated impacts, respond to ongoing complaints and notices, and in some, addressing these unaddressed corrective actions makes it appear that staff is managing the situation instead of the operator, and this is an enormous demand on staff's resources. This isn't how the rules or our staff is designed to operate in Colorado. I did direct that this matter be pushed to a consolidated hearing. At this point in time, staff feels like we are out of tools, and we hope that the commission can help us craft a solution to address these impacts. Again, and I want to reiterate something that Mr. Axelsson said very clear. Our goal is to ensure that impacts are addressed. He spoke to some specific examples, and you've asked for more information about these corrective actions that we think could be important. And these corrective actions tie directly to the violations that you have already found have occurred, where it is important that KPK proactively plan in this matter and their operations going forward, given the number of impacts that we've seen and that you've heard today. We think it's most important that you require KPK to report to you, and allows this commission to monitor the path to return to compliance and compliance with the rules and act as drafted. We think that there are other tools available to the commission. You may find a pattern of violation. You might find aggravating factors to change the penalty, and you may or may not consider the ability to pay. You may also suspend the certificates of clearance until the corrective actions are complete. You could suspend some or all of those certificates based on the NOAVs before you. I would note that the certificates are noted whether they relate to the 901A order or are associated with the NOAVs. Our purpose in elevating this to you has been and continues to be to ensure that the impacts from the operations at issue and before you today are addressed and cleaned up in a manner that is consistent with Colorado's expectations. It's unfortunate that we find ourselves in a unique circumstance such as this, but we staff think it's very important for you to be aware of it and you to help us guide this ship going forward. And that's all I have, Chair.
Thank you, Director Murphy, for that presentation. Mr. Jacobs, do you have any cross-examination of Director Murphy?
Yes, Mr. Chair, I do have some questions for Director Murphy, if I may.
Go ahead.
Thank you. Director Murphy, is it fair to say that selection of the 901A order locations by staff was based on surface conditions at those locations?
I believe it was the impacts associated with those locations.
But it did not, well, you did not specifically consider the impact of the 901A order closures or shut-ins on the operating pressures within the flow lines serving KPK's wells, did you?
You're correct, Mr. Jacobs. We considered whether eliminating operation of the well would eliminate the pressure source to the impact that we had observed.
But not on the operation of the system, is that correct?
That is correct.
Thank you. Additionally, you've been advised by KPK of two separate instances of Cogcc staff disparaging KPK to its vendors in recent weeks. Have you
Objection, this is outside the scope of this hearing.
Sustained.
May I provide a rationale for the question, Mr. Chairman, to make my record and offer proof, if you will?
Okay.
If staff is in fact doing this, as has been reported to the director, and if she's investigating it, it just greatly complicates my client's ability to conduct its business if staff is undermining its contractual relationships with vendors and employees. It's part of staff's influence on my client's ability to operate its business.
Okay, you've made your record sustained. Next question.
Thank you. Director Murphy, have you ever directed staff field inspectors to scrutinize KPK facilities more rigorously than other operators and to be sure and always find something to write up for corrective action?
No,
Are you aware of your enforcement managers ever instructing field inspectors to do this when inspecting KPK facilities?
no.
I'd like to share my screen. I'm showing you an affidavit of Mr. John Montoya, who is a former field inspector from 2011 to 2019, if you notice in paragraph 3 there. And Mr. Montoya, down here at the bottom, indicates that he was instructed by his supervisors at Cogcc to target KP Kaufman Company by increasing the inspection frequency of KPK's wells, flow lines, and associated production equipment, and that he was also instructed to be overly critical in his inspections of those facilities. I'm providing this as KPK Exhibit 21. I'm happy to provide an original, signed and notarized original of this affidavit to support the information and make it part of the record.
I would object to the introduction of this. This was not disclosed prior to this hearing, and you had adequate opportunity to disclose this information.
This was signed Friday, late Friday. It was not brought to our attention until a day prior, and it is directly relevant to staff's dealings with KPK. You're alleging a pattern. This is evidence of the ability to manufacture a pattern. I consider it highly relevant.
Could I ask a question associated with this particular affidavit?
Mr. Chairman?
Go ahead, Ms. Stafford. You can ask your question.
Who does Mr. Montoya currently work for?
I believe he is unemployed and he is recuperating at Anschutz Medical Center from back surgery.
Has he ever worked for KPK?
To my knowledge, no. I first heard of Mr. Montoya 2 days ago, 2 work days ago.
Well, my objection remains. This person isn't a witness, and his testimony should not be allowed.
Mr. Chairman, I think my record on this is clear. I believe this is highly relevant to these pattern of violation allegations.
Okay, we're gonna let it in. We're going to give it the information each commissioner can think through. Do you have any further questions, Mr. Jacobs?
I do not, Mr. Chairman. Thank you, Director Murphy.
Ms. Stafford, any redirect?
Yes, if you could just give me a brief moment to collect myself.
Sorry, Ms. Stafford, are you ready?
Yep, thank you.
Go ahead.
Just one brief question. Director Murphy, with respect to the affidavit that was just shown, did you have any knowledge of this particular employee making their understanding of potential inspection directions made?
No.
And did you personally direct this employee to act in the way that he acted.
No.
I don't think I have anything further.
Okay, thank you, Ms. Stafford. Director Murphy, getting back to more relevant considerations from your testimony, you speak to that you feel that you're out of tools and you ask the commission to craft a solution for us, want KPK to report to us. And I guess my question is, today I've heard from your staff kind of, and I don't know if it's conflicting or maybe it's just they correlate, but there's the request from Enforcement Officer Farron for a high penalty using the aggravating circumstances if that were to be found. And then we heard from Mr. Axelsson that the other team, the enforcement team, really is interested in getting into compliance, getting KPK, to do corrective actions and a compliance plan. And I just wanted to give you the opportunity as director to sort of frame the ask from staff. Is it both? Is it one more important than the other? Do you have an opinion? Just kind of an open-ended question along those lines.
Thank you, Chair, and I almost always have opinions, so thank you for the opportunity. The priority, I think, that the Act sets out for us and that I take most seriously as director is eliminating, preventing or eliminating impacts to the environment associated with oil and gas operations in Colorado. So that is, to me, the most important component. The appropriateness of the fine, I think, is squarely before you as commissioners, because staff did elevate this. We did not negotiate an AOC that would resolve the penalty amounts and corrective actions. And we think that those are important considerations for you to weigh on balance with the benefit of the information that the parties have presented to you. That said, our primary goal in the outcome of this hearing is making sure that impacts are cleaned up and addressed in a timely manner, with a penalty to be imposed as you deem is appropriate given your authority and responsibility to administer the Act. Does that help, or did I just rearrange deck chairs?
No, that's very helpful. Thank you very much for the additional information supplied to us. Do other commissioners have questions? I'm going to look at my notes and see if I have anything further as well. Okay, I don't think I've got any further questions. I'm not seeing commissioners with further questions. Ms. Murphy, I believe we will let you go. We did direct a member of your staff to undertake some homework. We look forward to receiving that, hopefully today if possible, and I know they're working hard. With that, it is 12:20. We do have scheduled a lunch break at 12:30. I suggest we go ahead and take a lunch break now. Actually, I'm sorry, Ms. Stafford, are you done with your witnesses? I think that's who you said you had.
Thank you, Chair. We have completed our witnesses at this point.
Okay, and then do you desire to do a closing following KPK's responsive presentation, or did you desire to do some of a closing now and then a rebuttal later?
I think it was our intent to do the consolidated closing that we had discussed at the beginning.
Okay, good.
I would note that we might need to file something to respond to this particular affidavit that was just introduced, surprisingly.
And you will have an opportunity to do so. With that then, as I said, let's go ahead and take the lunch break. And let's return at, say, 1 o'clock?
I'm sorry, Chair Robbins, could I interject just one more time?
Go ahead.
Could I have a copy of the affidavit that Mr. Jacobs just put on the screen?
Mr. Chair, I'd be happy to provide that to Ms. Stafford and the hearings manager.
Yeah, actually, if you could just e-file it, Mr. Jacobs, then everyone would have access to it. That would be helpful.
We'll do that
okay.
correctly, Mr. Chairman. Thank you.
Anything further, Ms. Stafford, before we break?
No, and I apologize for interrupting.
No, not at all. Okay, we will return at 1 o'clock. And at that time, we will hear from KPK. Have a nice lunch. Okay, folks, I see we're all showing back up dutifully. Thank you very much. I'm not completely done with my lunch, so I will probably be video off for just a bit. But that doesn't mean I'm not listening. I'm looking for Miss Stafford. It doesn't look like she's a panelist.
Maybe Mr. Jacobs also, somebody sent you an email about elevating the witness room for KPK, and one of his, another DG.
Hey there, Miss Stafford. I think we've got you back. Did you have anything further before we move over to KPK at this time?
I do, Chair. Just one brief thing before we move to KPK's presentation here.
Okay, then let's just continue forward with your case in chief.
Thank you, Chair. I would just like to respond to the back and forth that just occurred over the affidavit. Over the break, we were able to confirm that Mr. Montoya entered his last inspection in February 2018. Additionally, it's our belief that Mr. Montoya did not enter any inspections that led to the NOAVs that were at issue in this particular enforcement matter, in this matter consolidated for hearing. We would be happy to call rebuttal witnesses this afternoon if you would like additional testimony, but we will stand on our objection from just a few minutes ago and once again express our frustration that an affidavit that counsel received 3 days ago and was just disclosed today was not provided over the weekend. We have no opportunity to cross this particular person, and he was not listed as a witness. And so I would just like to relodge staff's objection to the entry of this affidavit into the record.
Okay, so noted. Then thank you for that. I, as one commissioner, do not need further rebuttal on this issue. I'm not seeing anybody else indicating a need for further rebuttal. So with that, we will turn to KPK and their presentation of their case.
And Mr. Chair, if I may just ask a quick question of Mr. Jacobs or Mr. Mueller. I'm looking for the KPK witness room. Are they yet in the Zoom meeting?
I think they may have to be made a panelist.
Yes.
Who is they? Like, under what name would we be looking for, Mr. Mueller?
I believe it's the DJS witness room.
KPK witness room.
KPK.
One of the two.
And I know in the past that's how we had them named. I'm not seeing that. Oh, here's a raised hand. So one moment. Would it be SJOS, perhaps?
Yes, that's it. That's
Okay.
my legal assistant. So
Okay.
she logged in. Thank you. SJOS is the KPK witness room.
Perfect. We'll rename them just so you know.
Thank you.
And Ms. Larson, can you provide Ms. Stafford with a time update?
Yes. So staff has used 1 hour and 10 minutes and 40 seconds. You have remaining 49 minutes and 20 seconds. Forgive me, I didn't have my microphone on. Staff has remaining 49 minutes and 20 seconds. KPK has remaining 1 hour, 34 minutes and 37 seconds.
Okay, there we go. We've got your witness room identified for you, gentlemen. You are on the clock.
Thank you. We have a witness who needs to be sworn in the witness room. It is Mr. Alan Harrison, and he was on our list before but did not testify, has not been sworn.
Okay, and you're not on the clock. We'll get the swearing in done first. Is that Mr. Harrison that we see?
Yes, I'm here. Can you hear me okay?
We can hear you, AG Davenport.
Thank you, Chair. Mr. Harrison, I'm going to ask you to raise your hand, and then all you have to do is say "I" and state your name and say that you swear to tell the truth. Go ahead, please.
I, Alan Harrison, swear to tell the truth.
Thank you.
Go ahead, Mr. Mueller.
Thank you, Mr. Chairman. Thank you, Mr. Harrison. Will you please introduce yourself to the commission and tell them what you do for a living and how you're employed?
Sure. My name is Alan Harrison, and I'm currently the Vice President of Engineering for Kpk.
And describe briefly your professional training and education.
Sure, I have a Bachelor of Science in Petroleum Engineering from Colorado School of Mines.
And tell us about your career prior to joining KPK.
Sure, I've been in the industry about 40 years. I've worked as a staff engineer in basically all aspects of petroleum engineering, which would include reservoir, production operations, as well as drilling. And then I eventually transitioned into management and leadership roles with various companies along the way. And my my experience in the DJ started back in 1996 with a company called HS Resources, who was the actual predecessor to Kerr-McGee, then Anadarko, and now Oxy, of course. And so I spent about 10 years working the DJ Basin as an operations manager out in their Greeley office, and then I was promoted to vice president in their Denver office.
And you were familiar with the wells and facilities that were being operated by HS Resources and the other companies that you mentioned in the DJ Basin.
Yes, at the time I was with HS Resources, Kerr-McGee, we grew our asset base from probably a little over 2,000 wells to over 4,000 wells. And part of that included an acquisition of the Amoco petroleum assets in the DJ Basin. And part as a subset of those assets were quite a few wells in the Spindle Field.
And you become familiar with the wells that are operated by KPK as well. Can you describe, please, the similarities or differences between the wells for the two companies?
Sure, at HS Kerr-McGee, the proportions were off, but at HS Kerr-McGee, we're probably 90% plus Codell, Niobrara, J-San wells. And their artificial lift was primarily plunger lift. And then we had the subset of spindle properties, which were all on pumping units at the time.
You've described for me, and I wonder if you could describe for the commission on a high level, the consolidation that took place by Amoco with regard to those facilities we've been discussing.
Sure, well, after we purchased Amoco's assets out there, we quite a few of their employees came along with the acquisition. And so I got a good history about their consolidation facilities. And it all started way back probably in the 80s, where they really adopted this concept of going to a gathering system with their properties. And so they proceeded to remove all the separators and tanks from their individual well sites, and then laid out a pattern of consolidation lines. And then the wells were connected into those consolidation lines.
Can you describe? Go ahead.
I was going to say, it was a great benefit for seeing at the time, because it not only reduced Amoco's footprint in the basin, but also it eliminated a lot of the heavy truck traffic, because before you were having oil transports and water transports having to drive to each of those locations and pick up oil and water and so forth. Now they could just go to a central facility.
So there were more flow lines and less trucks. Is that fair to say?
Yes.
Can you describe the flow line structure and infrastructure, please?
Sure. I'm going to speak from my firsthand experience when I first came across these properties at HS. In almost every case, the flow lines were constructed either with 2 or 3 inch fiberglass, and then those were then run over to the consolidation line, sometimes to a manifold, and then from the manifold to the consolidation line. The consolidation lines ranged in diameter from 6 to 10 inches. And the reason that they had done it that way is because you were collecting a flow from, depending on which part of the field, you could be collecting quite a bit of volume. And so I think they tried to size their pipe accordingly to keep their pressures down and so forth. But the fiberglass, I think, was chosen out of cost, speed of installation, and then, as you heard earlier, corrosion is not a problem in this kind of environment using fiberglass. And they knew that they were going to have fiberglass pipelines of various lengths, with water, oil, and gas, being in those lines for long periods of time. So I think the fiberglass made a lot of sense to them. The only shortcoming about that is they failed to use what we would call a tracer wire to wrap around those fiberglass lines, which give you the ability to later locate those lines using the standard magnetometer that you see being used for line locates.
And these lines,
So-
again, a substantial number of these are now the property of KPK, correct?
Yeah, that is correct.
And from time to time, KPK has to relocate or repair or otherwise access fiberglass lines and prior flow lines from the earlier operators. You've been familiar with that process, am I right?
Yeah, I've actually been involved on a first-hand basis, usually working with the developer where they've requested that KPK either relocate or realign their flow line. And in all those cases, we look at the project scope of what we're trying to accomplish. And every opportunity that we can, we'll replace that fiberglass line all the way back up to the wellhead with a high-density polyurethane pipe, which we refer to as SDR11. It's a special dimension ratio type pipe. And so we will utilize as much of that pipe in the project as possible. And we see that as an upgrade to the system, if you will, for, in that particular area.
What do you do about the problem of locating the line with it?
See, I didn't hear that question, Kurt.
Sorry, what do you do about locating the replacement lines? How do you provide for that?
Well, that could be a challenge. In some cases, it's pretty obvious how the flow line path might go. Traditionally, you would try to follow a lease road or something like that. But, back then, a lot of these areas were just open fields at the time. So what I've run across, and we ran across even at HS, is sometimes they just take the most direct path from the wellhead to a manifold point or to the consolidation line. And in those kind of cases, you have to, if you're going to remove that line and locate it, you have to start just digging along the path of that line and keep exposing it. You really can't locate it. But once you start to get the sense of direction, you can follow through the excavation as well as potholing.
With the replacement lines, in addition to upgrading from fiberglass, what else do you do to secure the new lines that you're upgrading?
Well, I think what you might be talking about, and I haven't had much firsthand experience do this, but I'm very much aware that where there's a situation where you can expose an end of the consolidation line and maybe another point somewhere further downstream. I know that KPK, it's a process they call stinging the pipe, where they'll actually run this high density pipe, polyurethane pipe, through the steel pipe, again, just to provide that extra bit of comfort, knowing that you have new pipe in there versus pipe that's been in the ground for a long time.
It's also easier to locate the steel pipe that has been stung with the plastic pipe, correct?
Yeah, it does, and that steel pipe also provides an extra barrier, kind of like casing.
In your experience, both as a developer who asked KPK to move lines and as somebody working for KPK, whenever possible and to the extent possible, does KPK upgrade the old fiberglass and steel lines?
Yes, in every case I've been involved with firsthand, definitely, most definitely. And I know that to be true on several other projects that I'm aware of, maybe not firsthand involved, but yes, they'll always take the opportunity to do that.
I don't have any further direct exam for this witness, Mr. Chairman.
Ms. Stafford, any cross?
Just a few questions, if that's okay.
That's fine.
Hello, Mr. Harrison. Thank you for being with us today. I just have a few questions related to your testimony here.
Sure.
Can you tell us exactly how many miles of lines KPK operates?
No, I can't. I can't tell you that number.
And do you know approximately how many lines you've replaced?
I've been involved with 3 projects on a first-hand basis, and I would say the collective footage of those probably was in excess of 5,000 feet.
And I guess when were those projects? When were those 3 projects?
I did the first one back in 2018, and then I'd say 2018, and then the most recent was right at the end of 2019.
And I think you might have mentioned, and correct me if I didn't hear this correctly. You said KPK upgrades these lines proactively.
No, these are done in response to a developer requesting a relocate or realignment of the pipeline because of its current position within the property. And so when they lay out their framework for a community development, for instance, they like to designate certain areas where these pipelines will run. And so in many cases, we'll either just move our pipeline over or we'll relocate it from the wellhead to get in the position that they requested.
So would it be fair to say that KPK only reacts and when they upgrade these lines, they only make a reactive decision?
Well, I mean, I don't know if reactive is the right word that I would use. This is really a collaboration with the developer under their surface use agreement. And so we work together as to defining the path. But yeah, it's not requested any place in the agreement that what type of pipe to use or anything. We go that route because, again, we know that it will eliminate a lot of risk by running new pipe and a pipe that also is non-corrosive in nature or not susceptible to corrosion.
So if they don't ask you to do it, you don't do it?
Well, if they ask us to move a line, we will do it. We will use the upgraded type of pipe.
Well, I guess I'll repeat my question then. So if they don't ask you to do it, you don't do it. Is that correct?
No, in every case that they've asked us to relocate a line, we automatically upgrade.
Okay, thank you. I don't have any further questions.
Yeah,
Mr. Mueller?
no further questions here either.
Okay, do you want to move to your next witness then?
Do the commissioners have any questions?
Oh, thanks. Sorry. Commissioners, does anyone have questions? Commissioner Messner.
Thank you, Mr. Chair. Just a couple of questions because I'm a little confused. I believe, is it Mr. Harrison or Harrelson?
Harrison.
Harrison. Thank you, Mr. Harrison. You had indicated that fiberglass lines were utilized because they don't corrode. Is that? But yet we've got a situation where the number one reason that we're seeing spills come out of these flow lines is corrosion. So maybe you can help me understand how they don't corrode.
Well, it's not internal corrosion as you might think, where you have a chemical reaction that's causing a degradation of the material. In the situations that I think were being addressed earlier, what you have are the installation process of fiberglass lines is very critical. They have to be padded properly and compacted properly. Without taking those kind of precautions, you become susceptible to, for instance, if there was rocks in the excavation ditch and you laid your pipe on top of some of these rocks, even small rocks, over time there can be enough movement just from expansion in that pipe to where you can start to erode some of the material, not corrode it. Okay. Likewise, when there's been these line crossings, these companies will typically cross their line underneath our line, in which case we have to expose our line. They run their line, and then you have to backfill that whole area. If you're not compacted properly underneath your fiberglass pipe, when you backfill the whole thing and there's any kind of subsidence downward, it'll cause a bending reaction in that pipe, and that pipe is very brittle, especially as it matures over time. And so those are the, that is something that I think was addressed earlier. The other aspect of the flow line is because we can't accurately locate a lot of these, depending on where they are along their route, you do have third parties accidentally, maybe hitting it with their backhoe bucket or something like that. So you have those kind of incidents as well. But I don't think we've discussed any, there's not any internal corrosion that's really occurring.
But there is the potential for internal failure of these from different ways of.
Yeah, different ways, correct.
Yeah, and I appreciate that. I think at one point that was asked what the specs were for these fiberglass lines and what the life expectancy of them was. Do you have any information on that?
You know, I don't, but I can tell you, like any type of manufactured product, you know, there are recommended practices, not only with the installation, how they're connected and so forth, but also what kind of operating conditions they're going to be put under. And that has a lot to do with the longevity of any kind of material. And so, you know, to say that the specs on the fiberglass line, I don't know what they are. You know, given that these were installed a long time ago, that would have been an amicable decision, and I'm sure they had to look down the road and have some kind of estimate as to how long these lines were going to be in the ground. Sure. But no, I don't have any specific specifications. I do on the poly pipe, but not on the fiberglass pipe that we typically are removing at times.
Okay. Thank you for that. And then help me understand too. I mean, my understanding is that there is the ability to run a wire. I mean, I know that there's tracer wires that you put in when you're installing new lines, but if you're really needing to know where particular lines are, there is mechanisms available to you in order to be able to run wire through that particular section of flow line to get an accurate an accurate measurement as to where it's at.
Well, yeah, so the tracer wires are installed externally. They're usually wrapped and taped around the pipe during the installation, for instance, on the poly pipe that we replace the fiberglass with. In terms of going inside the fiberglass pipe, I don't have any firsthand experience using any kind of wire that you might be able to run through. I do see some difficulties potentially in trying to do that because of the 90-degree turns and various other things that you know could cause some interruption and try to feed a wire through a piece of pipe. Plus all the you know disconnections that would have to be made in order to you know even get the wire in there. So I'm not familiar with that being done and don't have any firsthand experience with that being done.
Okay, thank you.
Mm-hmm.
Commissioner Nanjappa.
Thank you, Mr. Chair. And thank you very much, Mr. Harrison, for your testimony. In some of these instances that you're describing with developers where you're relocating lines, how are they encountering these lines? Is it upon their own excavation activities as part of development, or what's happening?
Now, usually on the front end, they'll come to KPK and ask us to locate our lines. And then based on the location of those lines, you know, they can come back to us and say, you know, based on our plan, our preliminary plans that we're going to submit to the various municipalities, you know, we would request if you could relocate a line, you know, along its current path to this other path that would, you know, potentially be next to a road that's going to be utilized where there'll be plenty of open space on either side of the road. So it really is a collaborative effort as to where the final flow line paths will be.
Okay. And so upon doing that, are you mapping where the new location of the lines are?
Yes, and in a couple of those cases, since we were actually doing a reroute, I can remember a specific project back in 2018. One of the things that we specifically request from the developer is if we're going to take a different route for our pipeline, our flow line, over to another point, for instance, that they provide us an easement describing, you know, that new flow line path. That way we can be assured that there won't be any type of permanent appurtenances placed on top of our pipe, plus give us sufficient room to access that pipe if need be down the road.
Okay. And so
that's something, if I can elaborate, that's something that wasn't done before because you don't see any recordings of these flow lines in any kind of county records. So this is a big benefit because now going forward, you will have a recorded easement even if it's just for a flow line in these particular projects that I've been involved with.
Okay, thank you. And so when the developer contacts you and they're asking you to locate the lines, what is your process for locating the lines?
Well, when obviously before excavation begins, you have to do an 811 call. So that prompts not only KPK, but any other utility or other oil and gas companies to come out and locate their lines. If there's a sense from KPK that we may not be exactly sure, then one of the things the developer will generally do is help by conducting some potholes. They'll ask us, well, at least give us some indication where your line goes, and they'll actually go out there and pothole to locate that pipe itself. And then once they do that, we have a pretty good idea of the accuracy of that locate.
Okay, so you're saying that in some instances the developers are doing the potholing for you.
Yeah,
and then you're learning where your lines are. Okay.
It's worked both ways. It depends on availability of a pothole machine and also on the I guess the urgency of when they want it done.
Okay. How much of like what proportion would you say of KPK's flow lines are now well known and mapped?
I can't answer that exactly. I know that's a project that's been undertaken, but I wasn't involved in that.
Okay, and when you're relocating these lines, are you replacing the fiberglass lines, or are you and putting in the steel lines primarily, or are you using fiberglass still?
And the projects that I've been involved with, the existing lines were undamaged fiberglass lines, but because we know that they're prone to things as has been discussed, we will replace those lines all the way up to the wellhead along this flow line path with this new SDR11 high density polyurethane pipe. Now, I should mention that in a lot of these instances that I've been involved with, the actual relocate pathway did not go all the way up to the wellhead. KPK has chosen to say, well, if we're going to expose this line, let's take it all the way back to the wellhead so that we don't have any portion of that flow line still being fiberglass line.
Okay, thank you. And then last question is, do you have a process for inspecting some of these older lines that you're aware of?
Well, I believe there's a rule in existence now where there is a pressure tests that are run on an annual basis, and I think that was discussed earlier because an audit of KPK's records were done in 2020. So that is a mechanism for for being proactive in testing their flow lines for integrity.
Okay, I mean, I'm aware of those rules. What I meant more was, I guess, you commented on some of the installation processes that, perhaps in the past they were installed improperly, and I'm just curious, are you doing, do you have a process to go in and kind of make sure that the lines are properly installed, or kind of go back in and repad or backfill so that they're more stable?
I think what we would rely on is, aside from these projects where we would replace the lines for the scope of the project, we rely on pressure tests. If you cannot hold pressure in that line, that would be an indication that there's a lack of integrity at some place, and at that point you would, go about trying to find what's causing that lack of integrity.
Okay, thank you.
Other questions from commissioners? All right, Mr. Mueller, do you have any redirect, or are you ready to move to your next witness?
We'll move to our next witness. Before we do, just because the day wouldn't be complete without technical difficulties, can the commissioners just indicate whether you were able to hear our witness clearly, or whether it's muffled?
I got a couple of messages that folks were not able to hear very well. I could hear, but I had to be very, very conscious in listening. So if there's a way to move the microphone closer or move the witness closer to them, I don't know, it would be helpful, I think.
Good. We'll tackle that. We appreciate your patience. We have another witness coming up.
Yeah. Okay.
Mr. Harrison, thank you very much.
Okay, you're welcome.
Yes, thank you, Mr. Chairman. I'll be directing the exam of the next witness, but if we could have just a couple minutes to do a quick sound and lighting check in there, I think everyone will benefit from that.
Yeah.
And we'll be quick about it.
Okay.
Thank you.
Yeah.
Does that sound any better?
Yeah, that sounds better. 1, 2, 3 testing. Let's hear it again.
All right, 1, 2, 3 testing.
Yeah, I think that's better. I'm seeing thumbs up from commissioners.
All right, if there's any other issues, let us know and we'll try to address them as they come up.
Mr. Kaufman, Jeffrey Kaufman will be our next witness. He's making his way to the witness room, if you'll bear with us. And he will need to be sworn in.
That's what I was thinking.
Here we go. Thank you, Mr. Kaufman. I think we're ready to get started, Mr. Chairman.
Okay, Mr. Kaufman, the Assistant Attorney General Davenport will have you sworn in. So let's find Mr. Davenport. Mr. Davenport, go ahead.
All right, sir, would you please raise your hand and then say, sir, would you please raise your hand and then say, state your name and say that you swear to tell the truth.
I, Jeffrey Kaufman, swear to tell the truth.
Thank you.
May I proceed, Mr. Chairman? Thank you. Please state your name and current employment position.
I'm Jeffrey Kaufman, and I'm President and CEO of Kpk.
And do try to keep your volume up. It's tailing off just a bit. Mr. Kaufman, how long have you been employed by KP Kaufman Company?
I've been full-time since 2010.
And briefly, can you describe your education?
Yes, I have a degree in electrical engineering from Lehigh University and 2 masters from Cornell University, one in electrical engineering and a master's in business administration.
Thank you. Mr. Kaufman, you've heard staff's testimony and their counsel's argument about an alleged pattern of violation in this portion of these proceedings, correct?
Yes, I have.
And do you recall their statements regarding flow line integrity and the incidents of spills and releases from KPK's flow lines and consolidation lines in connection with the Rule 901A order?
Yes, I do.
You take issue with staff's characterization of KPK's flow lines, their integrity, and the company's efforts to maintain them to prevent spills and releases?
Yes, I think it's been mischaracterized.
Mr. Jacobs, can I interrupt? Mr. Kaufman still sounds a little muffled, at least to my ears.
Yeah.
So I don't know if there's something we can do, but I think it would be very helpful. I do think you want him to be heard.
I do, absolutely, and I appreciate your interruption. Could we take just 5 minutes and get this sorted out? I do apologize.
Let's return at 1:40, and that'll give you
so
4
much.
minutes to get things straightened out.
Thank you. Thank you, Mr. Chairman.
Okay, Mr. Jacobs, do you want to have your witness do a testing 1, 2, 3?
Go ahead, Jeffrey.
Testing 1, 2, 3.
Oh, that's awesome. Yeah, we can hear you a whole lot better, and we can see you.
Oh, good.
Other than that, how are we? Thanks, Jeffrey.
Okay, we'll wait for Mr. Jacobs to show back up. Mr. Jacobs, I will not start the clock, and if you want to like start this area of inquiry again as opposed to where you left it off in the question, and then we'll start the clock once you get to the question that you were leading up to. I think it's just unfortunate that you're kind of got stuck in the middle.
I'm fine with backing up a bit if you don't mind pausing the clock until we get to where we were.
That'd be great.
Okay. I think we covered your educational background. Mr. Kaufman, you've heard staff's testimony in their counsel's argument about an alleged pattern of violation in this portion of these proceedings, correct?
Correct.
And do you recall their statements regarding flow line integrity and the incidence of spills and releases from KPK's flow lines and consolidation lines in connection with the Rule 901A order?
Yes.
Do you take issue with staff's characterization of KPK's flow lines, their integrity, and the company's efforts to maintain them to prevent spills and releases?
I do take issue.
Can you elaborate? Let's try to break that down. Is there something about KPK's fiberglass flow lines that, or their age that causes them to be more prone to leaks?
No, fiberglass is an excellent material. As we've discussed, it's non-corrosive, both internally and externally. Once it is buried in the ground, you don't see corrosion and those types of issues. Also, these flow lines were installed, with knowledgeable people who did know how to, compact properly and make sure that the material was free of rocks.
Very good, thank you. And if care is not taken in that manner, compaction or keeping rocks out of the backfill, what can happen?
Well, unfortunately, you can have spills and releases. Due to subsidence, you can create a crack in the line, and we have experienced that with several line crossings.
Thank you. Does KPK take care to backfill without rocks and to compact properly?
Yes. When we work with this material a lot. We understand the material, and we know how to handle it and how to backfill and compact so that it does have integrity for a very, very long time.
So, why is subsidence a problem? Isn't it just your problem?
Well, unfortunately, we're in a mature producing oil field, but we do have, other operators around us drilling to different formations, drilling horizontal wells, installing new flow lines, new gathering lines, and crossing our infrastructure rather frequently. And when they do, they will, trench across our existing line, put their lines underneath our lines typically, and then they will backfill. And we have had issues where if they don't backfill properly, our line can have a failure.
So you have personal knowledge of this occurring where there's subsidence caused by a third-party line crossing one of your lines?
Yes.
And have you taken pictures that illustrate that problem?
I have.
I'm going to share a screen and show you one of those. Do you see this photograph?
I can.
Can you describe what we're looking at, Mr. Kaufman?
Yeah. So the orange line traversing the photo there is KPK's fiberglass flow line. The two green lines are, producers' flow lines, or gathering lines. And you can see they trenched across our line and backfilled poorly, unfortunately, causing our line to crack. You can see the released oil and water, which, you know, is a small amount, but still it saturated their trench and went straight up the path of least resistance to surface and daylight.
Thank you. And do you know this location offhand?
This is the Costlet number 3.
Thank you. Is this an isolated instance in your experience, this kind of third-party crossing and crack of your line due to lack of care in the backfilling of the trenching?
No, it is not. We've had several instances.
Are there other circumstances where a third party's activities cause a spill or release from KPK's fiberglass flow lines in your experience?
Yeah, I mean, not only can it be from improper backfilling, but we have properly located lines, you know, to address Mr. Messner's question a little bit to Alan Harrison. I was listening. We do have something called a traceable rotor where we're able to put it in the flow line and you can then you can see it with a magnetometer and locate it. But that is a rather invasive procedure. You have to dig up the line, cut the line. And usually these locates, they don't give us enough time. So anyway, we do pothole and identify lines, and we have, you know, even with these methods, we have had third parties hit our lines and create leaks.
And it's share screen again, and I'm showing you a picture. Do you recognize this picture? Oh, here it is. Sorry, always one more step.
Yes, I recognize that picture.
And is this a picture of the Charter Schneider tank battery location?
It is. One of the,
and you'll notice upper left, this is Cogcc document 690-100-615. I believe it was actually a part of staff's Exhibit 5 originally, but we're utilizing it for purposes of this third-party line strike. Is that what we're looking at here, Mr. Kaufman?
Yes, in this particular instance, the lines have been located. They actually trenched and installed their line. They backfilled, and then weeks later came back and re-excavated, I believe, without an 811 call, and hit our line.
And that caused the leak dripping down onto the green line here that you can see from this part of the pinkish, reddish fiberglass line that I'm circling my cursor around?
Correct.
Thank you. And this is not avoidable through the use of an 811 locate for your line? Is that, am I understanding that correctly?
Yeah, I mean, in this case, they did call an 811 initially. We had located it, they installed their line, and then I'm not sure why they came back, but they struck our line. You know, in cases where we do have 811 calls, we will go through historical maps and our knowledge of the lines and try to locate them as best as possible. If we have the time, not if we have, you know, but usually these 811 calls, you have to respond really quickly, and it takes more invasive measures to locate our line. We have to use a pothole, hydrovac and pothole, or we could use the traceable rotor, but usually they want to move really quickly. And so what we'll do is we will, you know, in cases where we know they're going to cross our line, we will lockout, tag out, or slot our lines, and we will flush the lines to ensure that there is no issue if they do encounter our line.
Thank you for that. So of the spills and releases from your fiberglass flow lines, in your experience, how many are due simply to the age and deterioration of your flow lines infrastructure as opposed to third-party activity?
You know, it's a good question, but really our fiberglass flow lines do not degrade with age. the impact on it. I mean, a lot of these lines have been in here for 40 plus years. If they were installed properly, they would have failed long ago. It's a matter of having this level of activity around us, be it another line crossing a line strike or just very heavy, construction equipment, moving across our line.
Thank you. Shifting gears a bit, we heard from Alan Harrison a bit earlier about how KPK upgrades a significant portion of its steel consolidation lines when addressing a leak, lining the larger steel line with HDPE or polypipe. Is that a common approach to repairing leaks since you've joined KPK?
Yes, it is. And before I joined as well.
Thank you. Mr. Kaufman, I'm going to share screen again with you and show you a map. This is KPK Exhibit 18. Do you recognize this map?
I do. This is our spindle low pressure consolidated system. The yellow lines are the original construction. The green lines are segments that we have upgraded with polypipe. And the blue lines are very recently acquired segments.
And is this all or almost all of the consolidation lines serving your spindle field wells?
Yes.
Thank you. Are there other examples of KPK going above the minimum requirements, not just to repair leaks, but to prevent them?
Yes. Not only have we proactively stung some of our lines, but we have installed compression to ensure that our system remains within normal operating pressures.
And what does that entail? What sort of capital have you invested in this compression?
So over the last few years, we've spent over $300,000 putting in compression at some of our major facilities and have plans to install compression at several more.
And what are your normal production fluid and flow line operating pressures for your three-phase production?
Typically 8 to 30 pounds.
Thank you. With respect to the 901A order that has had an effect on the operation of the low pressure flow lines and consolidation lines that connect many of your spindle field wells?
Yes, it has. Shutting in some of the gassier wells on the tail ends of the system, along with some topography, has made it, we've seen significantly higher pressures.
Can you elaborate? What sort of pressures are you seeing?
Yes. So, I mean, three-phase flow is unique, and in lines of this size, and we have we need the gas flow to continue pushing the product along the terrain to our consolidated facilities, and because we've lost that production. We've now noticed hydrostatic columns are forming and creating a much greater pressure at the tail ends of the system in certain topographical locations. And so, normal operating pressures, say even on the back end of the system, should be about 30 pounds. And we're seeing in cases 80 to 100 pounds.
Thank you. So is it your opinion that the imposition of the 901A order may actually be increasing the risk of spills and releases rather than preventing them, as perhaps
Yes.
intended? I'm
Yes.
sorry, say that again.
Sorry. Yes. I apologize. I stepped over you there.
Thank you. Finally, we've heard from staff about their frustration with KPK's pace of remediation and closure, but this is not just a function of KPK's resources, is it?
No. We have many locations, unfortunately, that, we have landowners to deal with or other operators, and they have their requirements and their restrictions, I guess, on our ability to access the sites and perform excavations and remediation.
Is the Coslet A9 location under the 901A order such a location
Yes, it is.
where you've encountered third-party access issues?
Yes. Very similar to the COSLA number 3, this other operator trenched around our lines. The ground subsided and cracked our fiberglass line. We did repair and replace the line with poly, but then continued excavating, and we excavated to the top of their lines and a little bit below, and they stopped us and told us that we could not excavate anymore.
And this is the line, the location where you're approved for daily vac truck removal of product and daily inspections, is it not, as we heard earlier?
Right, yeah, so because we are no longer allowed to excavate and remediate any further, we are checking it daily, and we are going with a vac truck daily and vacuuming out any free product.
And this line here is your line, but that's the poly pipe that you replaced the fiberglass with. You can see how it's flexing and bending.
Correct.
Thank you. I have no further questions for this witness at this time.
Ms. Stafford, any cross-examination?
Just a few questions. Hello, Mr. Kaufman. Thank you for being with us today. We appreciate your testimony. So I'd like to ask just a general question first. So you mentioned you are the Chief Operating Officer of KPK. That's correct?
That's correct.
And about how many environmental professionals work at KPK?
Our environmental department has 3 people, and we're looking to hire more.
3 people to manage 1,200 wells across the state?
Yes, we use some other firms as well.
Thank you. I'd like to move to your discussion with your counsel about flow lines. Can you describe how many miles of flow lines have been replaced by KPK recently?
You know, I don't have that number offhand. I'd have to look it up.
You know the engineering specs of these lines that were replaced?
Alan Harrison, I think, is a better person to ask that question to, but.
Understood. Thanks. And do you know who installed the lines that you were replacing?
My understanding is that the majority of it was installed by Amica.
Okay. And you mentioned that KPK works with fiberglass a lot and intends to keep its integrity. Is that right?
Yes.
And you said, I believe you also said that fiberglass doesn't degrade with age. Is that right?
Yes.
And yet KPK continues to have spills and releases across its system?
Yes.
Now, is it cheaper for KPK to locate the line than it is to clean up the spills?
It's not a matter of locating the line or not. We never want to have a spill. I mean, of course it is cheaper, but there are many other factors.
And what are those factors?
Well, unfortunately, a lot of these companies that are crossing our lines, they don't come to us like the developers and say, okay, hey, let's work together, let's figure out where the lines are and do what we need to do. I mean, we'll get almost no information from them other than the 811 call, which is just do you have a line in this area? So we wish we were able to work with a lot of these other parties more. And if we are provided the opportunity, we usually, we'll figure out where their crossing is. We'll put in a protective casing around our line, and we'll try to stay in front of it. But we don't, if we don't know, we don't know.
Well, speaking to that a little bit, is it KPK's general practice to proactively reach out to these parties?
We don't you know, through 811, you don't really know. I mean, we are not aware of their construction and plans until they are, you know, practically putting a shovel in the ground. So.
Okay, thank you. I thanks for that answer. And I think you spoke a little bit about subsidence and then others backfilling particular excavations. Now, does KPK perform daily oversight of these excavations and this backfill procedure?
You know, it depends on the situation and the you know, the parties involved and what's going on, location specific.
So KPK does not perform oversight on backfill that's occurring at their lines?
We may, if we are privy to it and we have the opportunity.
Could you give an example of when you would provide oversight?
Yeah, you know, if we're working with any party who's around our lines, you know, if we have an agreement in place or a knowledge of what they're doing, knowledge of their construction, whatever's happening, then we will provide supervision and oversight.
Okay. And let's say we assume a line is damaged by a third party, as you've indicated in your testimony. So is KPK responsible for reporting that spill?
Yes.
And KPK is obligated to respond to that spill?
Yes.
What about responding to other COGCC directives? Is KPK obligated to do that under the rules as well?
Yes, if they're directed towards us.
Could you briefly, or if you know this, that would be very helpful, but about what percentage of KPK spills are someone else's fault?
Unfortunately, I don't know that offhand. I'd have to look at those statistics.
Okay, well, I'd like to at least direct us to the particular spills and releases that were at issue in the enforcement hearing. If I could just share my screen for a second here. Can you all see that?
Yes.
Okay. Now this is a collection of some of the, I believe, demonstratives that we showed during the portion of the hearing that we had last month. And this particular one deals with the NESU #1 flow line. Now, was that spill someone else's fault?
You know, unfortunately, I'm not too familiar with the cause of the NESU leaks, but the NESU wells we did not own for very long prior to these leaks. We took them over and
but they were KPK's wells and lines when a spill occurred.
Yes.
And what about for the NESU consolidated line? Was that somebody else's fault?
Again, I'm not quite sure what the cause of failure of that line was.
Okay, I'm going to stop sharing. It appears maybe I might need to direct these questions to someone else. But I guess overall, you are unaware of whether any of the 7 NOAVs that were at issue in the enforcement hearing, any of those spills were caused by someone else.
I would have to review that information.
Okay, and then I just have one final question. Have you, as the chief operating officer, directed your staff or your lawyers to pursue a different responsible party for any of these spills?
We have. We have been in negotiations with these the parties involved in the Cogcc leaks. We have engaged in multiple meetings with them. We've tried to get them to give us some direction and take some responsibility, and unfortunately, those haven't beared fruit yet. But we have had multiple meetings and are working on it as quickly as we can.
Just, and I apologize for interrupting, but just for my own clarification, are the responsible parties you're pursuing, are they anyone associated with the NOAVs that we dealt with during the enforcement proceeding?
I don't believe so.
Okay, thank you. I don't have any further questions.
I'm wondering, I'm not sure I understand that last question, Ms. Stafford. Mr. Chairman, if I may ask for some clarification. If the third parties you're dealing with, Mr. Kaufman is dealing with, how do they relate to the NOAVs?
Well, that's our question as well. So that's why we asked it. We're wondering if KPK has pursued any of the operators that they are asserting are responsible for the historic contamination at these particular locations.
Okay, and I believe Mr. Kaufman answered that yes, he's in discussions with third parties at several locations and trying to get them to do the right thing. So thank you for that clarification. Nothing further, Mr. Chairman.
I would like to clarify one thing. I believe he mentioned that they were not specific to the locations that we dealt with in the NOAVs.
If I may, I think that I was answering a slightly different question. And yes, we are and have reached out to other parties that we think are responsible for these for this contamination in the NOAVs and others.
Okay.
Hey.
Okay.
Anything further, Ms. Stafford? Okay.
I don't believe so.
Mr. Jacobs, you said you didn't have any further questions?
Just clarifying that the Coslet A3, that last picture we looked at, and the polyline you had replaced over it where you're have an access issue to engage in further excavation to complete the remediation. That's a 901A order location, not an NOAV location, correct? Mr. Kaufman?
Yes, yes.
Thank you. That's all I wanted to clarify. I have nothing further.
Okay. I'm starting to get confused about who's testifying, who's asking questions. So with this, let's turn to commissioners. Do commissioners have questions of Mr. Kaufman? Commissioner McGowan.
Thank you, Mr. Chair. Thank you for being here today, Mr. Kaufman, and testifying. Could we go back to the number of lines that you have and that map that Mr. Jacobs showed us? It sounds to me like some of the issues around fiberglass lines are the fact that we don't know where they all are because they don't have those tracers in them. I'm wondering, and maybe you don't know what you don't know, but of the percentage of lines that you own, how many have actually been mapped and how much remain yet to be mapped? Do we know?
I believe we've mapped all of the lines. The level of accuracy can vary. Certainly steel lines are easily locatable and have accurate descriptions, accurate mapping. The fiberglass flow lines, it just depends on the quality of the initial maps. Sometimes they do have tracer wire with them. A lot of them don't. And so, the accuracy can be lower on them.
Thank you. So in these cases where a third party may have affected your line, if almost all of your lines have been mapped, I'm curious to know after an 811 call why there are these issues with another operator interfering with your line and affecting its performance, nicking it or causing it to break. I'm just curious to know why that would happen if your lines have been mapped and you've told the other operator where your lines are.
So a lot of our issues are around backfill and soil settling, which, is not a case where they know where the line is. They trenched over the line. The line was not damaged during the trenching itself, I don't think, but it was damaged afterwards after the soil subsided. So in that case, knowing the location of the line is not going to help. We do have cases where, again, we do have a lot of crossings and most of them result in no leaks and no problems, either because they were properly located and properly crossed and trenched across. But on occasion, unfortunately, even if they do know where the line is, they're digging across it and they can nick the line.
Thank you. Do you, when you all acquire assets, do you do some sort of assessment on the resources? Do you do soil samples? Do you do line integrity testing? Do you try to figure out what condition the assets are in before you acquire them?
Yes, we do. We do due diligence. We will go and inspect the facilities and inspect their and pull their historic documents. We'll certainly look if they have any open remediation projects, anything of that nature, and that they're up to date on their flow line testing, and that their equipment looks and sound and they have maintained it. And certainly we don't want to buy equipment that is not in good order.
Thank you. So in general, I guess my assumption would be then after you acquire an asset, you assume that there is no leaking or spillage or some problem with the asset because you've done an assessment upon purchase.
Yes.
So how long after an operator owns an assessment do you think there's this turnover from historic somebody else's problem versus I've owned it for 20 years and perhaps I have responsibility for what has happened on that site?
Question. I don't know if I have an answer for you though. And
it's not a trick question. Some of what I've been struggling with has been how we determine whether something's historic or it should be the actual operator's responsibility, because it's been in the under the operator's control for quite some time. So I'm still trying to needle my way, work my way through that one. I think that's all. Thank you very much.
Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Mr. Kaufman, for your testimony. I just had a couple of kind of more general questions. As Chief Operating Officer, do you have training requirements for your staff with respect to our Cogcc rules?
Yes, I do.
Can you elaborate and tell me how you how that works to ensure that staff are aware of compliance requirements?
Yeah, our environmental staff, well, you've met Max Knaup in prior hearings. He's developed multiple training programs. He reviews the rules himself, and he will develop materials to give to our field personnel and other staff on whatever various applicable Cogcc rules.
And how frequently do you conduct those trainings, or does Mac? I mean, I understand we probably will be hearing from Mr. Knaup, so I can ask him as well. But to your knowledge, how often do those training activities occur?
I would have to get with Mr. Knaup on that response there.
Okay. And what about following some of the past incidences, with the AOCs that have, that have now been confirmed? Do you conduct sort of a postmortem? Do you have a discussion on changes in operations?
Absolutely. We've learned a lot of lessons, and we have changed our operations and emphasized a lot of the BMPs and important standards we should be following. And we, in an effort to ensure that our staff is following all of those.
Okay. And so would it be fair to say that following a past instance, that you are taking steps to ensure that the rules are known and what needs to be undertaken the next time something like that happens?
Absolutely.
Okay, thank you.
Mr. Kaufman, when did that take place? This learned your lessons, changed our BMPs, taking steps to ensure rules are known and what needs to be done. When did that occur in your company?
It's occurred over time as the rules have changed. Certainly in the last month and the last few months, we've had quite a few meetings about the importance of a lot of the various rules, regulations, BMPs. Reinforcing how important compliance is and focusing on it.
Did you hear Director Murphy's testimony earlier today?
I did.
Yeah, and so Director Murphy testified that she and her staff felt like they were out of tools, that they were having to sort of operate for your company as opposed to you doing the work that needs to be done. Is this last few months of meetings, is that to try to accommodate that concern? Do you agree with that concern? What's your position?
Well, we are putting all of our efforts behind compliance and making sure that we're in compliance and can get into compliance and remediating these sites. And, admittedly, we have encountered some difficulties at some sites, due to access and due to landowner, farmer requirements or infrastructure and not impacting that infrastructure. But anyway, we, to answer your question, we are acutely focused on cleaning up these remediation projects.
So, and I asked, did you hear the testimony of Environmental Manager John Axelsson?
Yes, I did.
Okay, and you heard me ask him to define out the asks that he said around the compliance plan and corrective actions and things of that sort. So I should be getting that later, hopefully as a filing in a written form. And again, we are being asked to look at payment, at POV, at inability to pay, at a lot of different things, right? And we're going to be asked to come up with a proposed answer, thought, et cetera, to that. I don't know, I've got a question, I've got an ask of you, but would you and your company take a look at what we get back from staff and be prepared to sort of talk about what they are suggesting or thinking about? And this is kind of this is part and parcel of what we have to do, is to come up with, an answer, solutions in this hearing. And it's strange because we're in a formal public thing, but I'm trying to proactively come up with methods to make this commission come up to the right answer for everyone involved. So I don't know if that's a question, it's more of a notion or a suggestion or a supposal.
Yes, and we'd love to be part of that dialogue into figuring out what a good workable solution would be.
Okay. Thank you for that. Thank you for your testimony. I have other commissioners with questions. I saw Commissioner Messner first and then Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Mr. Kaufman, for your testimony. I think one of the things that struck me from the testimony, and as well as some of the pre-hearing statements, is that it seems like a lot of these situations are someone else's problem. I think you're indicating or seem to be insinuating that the spills associated with KPK were caused by a third party, or the remediation delays are caused by a third party, or there's historic spills associated with these, which is a third party situation. And I think you've been asked the question, how much is actually your responsibility? Are you trying to insinuate that the majority of these situations, these NOVs, these spills, and situations that have brought us here today are not KPK's responsibility?
I think we got to analyze it case by case, but there are a good number that, where another company has damaged our lines, and, in a civil proceeding, I think that would be their responsibility. I'm not a lawyer, and I can't speak to that, so maybe I'll leave that alone. But
So following up on that just a little bit, I mean, if we've got a situation where, in your words, a third party is causing a significant numbers of spills that potentially costs KPK millions of dollars, would there not be some responsibility from the KPK to actually address those situations proactively in order, at a minimum, to save KPK potentially a significant amount of money, but probably more importantly, to preserve public health, safety, welfare, the environment, wildlife resources in a responsible operating manner?
yes, and where we're given the opportunity, so where we have another party communicate with us, tell us their development plans, we can say, okay, our line's here, your line's going in here. We will certainly work with them. If relocation is the best solution, we will relocate the line. If it's as simple as a crossing, we will and prefer to be able to remove a section of our line, put in a steel casing, and then replace the line that's crossing, so that we don't have any sort of subsidence issue or anything like that. So absolutely, I mean, where we are afforded the opportunity to be proactive, we absolutely want to, and it is the quickest, easiest solution. Unfortunately, the way that things work out sometimes, I mean, there's no requirement for them to reach out or even notify us that there is any sort of development. And we have been frustrated by those situations.
So we just went through and heard and confirmed a number of different NOAVs over the last month, and a lot of those did include associated spills, and some of those spills were actually brought up today during testimony and asserted to a third party. But yet I'm not recollecting through the initial NOAV discussions that there was a cause for these particular situations provided to another operator. And so explain to me how this has changed between August and September, that it is not KPK's responsibility, but it is rather somehow a third party's responsibility for spills associated with flow lines owned by KPK.
Well, I suppose I'm conflating the NOAV locations with 901A locations, and they, we'd have to get into the specifics, I suppose, of each location and what happened, and the cause and what we can do to prevent them in the future, and those sorts of things. Without breaking it down, I guess it's difficult to answer your question.
So, I do concur with Chairman Robbins' thoughts around taking a hard look at what comes from Mr. Axelsson. I think we all need to take a hard look at that. My father often told me that, ownership owned my responsibilities. And so I think this is an opportunity to take a close look at that. So thank you for your testimony.
Commissioner Najapa?
Thank you, Mr. Chair. And thank you again, Mr. Kaufman, for your responses. I just had kind of a quick, another general question. Have you had direct communications with Cogcc staff in relation to some of these matters, spills, et cetera, or is that primarily other staff at KPK?
Personally, I have not. I'm sorry for cutting you off.
And we have some exhibits that include emails between staff and KPK, and have you heard from your staff what the nature of that sort of those communications are? You know, are they? Have you been hearing? You know, are they helpful, not helpful, adversarial? You know, do you hear anything about the way the communications are between COGCC and KPK?
I I have heard some. I hope that our working relationship between the COGCC staff and KPK staff is improving. You know, we certainly want to have an open dialogue with staff and work with them and ensure that that any of their concerns are addressed and that we're proceeding appropriately.
Okay. And with some of the past questions I was just asking with respect to training and kind of ensuring compliance, you know, are you, have you included things like calling COGCC staff to ensure, you know, kind of what is the necessary step to take, or what is the rule that might be at hand for a particular matter?
I think that's left with our environmental staff.
Okay. Okay.
So, you know, they know how to communicate and come up with good solutions.
Okay. Thank you.
Commissioner McGowan?
Thank you, Mr. Chair. And sorry, I realized I had a couple more questions. They're kind of all over the place, so forgive me. When I think his name was Jeff Peterson, and I think he's on your roustabout crew. I hope I have this right.
Yes.
I felt like when he testified a few times, when we would ask, well, why is this not completed, this project? Some of his responses were, we had to go respond to another spill. I'm wondering if you could address what you consider your resource situation and KPK's ability to take care of problems when they arise and see them through to resolution, and whether or not your firm is appropriately resourced to do so.
Sure. We have, excuse me, we have increased our staff recently over the last few months. You know, we've also used a lot of third parties, be it you know, third-party roustabout and trucking companies, third-party environmental companies to supplement our resources. So we have brought in more resources. We've acquired additional equipment. We are certainly making the investment to clean these up as quickly and appropriately as we can. You know, COVID was difficult over 2020, and we did have numerous employees out, whether they had COVID or were quarantined for 10 to 14 days at the time. And that was difficult to work through. But no, you know, recently, certainly we're adding even more resources.
Thank you. And sorry, they're all over the place. Could you give me some examples of why, when you're in the middle of remediating or fixing a spill, can you give me specific examples of why landowners are deciding not to provide access any longer?
Yes. I mean, it could be a number of reasons.
I'd like the specific examples, maybe related to some of the NOVs we've been discussing. That would be really helpful.
Sure. Well, I can think of some related to the 901A order. But specific examples, you know, there's an irrigation line crossing near one of our excavations, and it looks like the contamination continues, you know, underneath that irrigation line. And if we disturb that, it will disrupt his irrigation, and he won't be able to do what he does with his water. You know, we've had some disagreements with some landowners, and you know, we try to take care of them. We do try to foster wonderful relationships with our landowners. I think many, many, many of them do appreciate KPK, and we take care of them. But you know, there are some that have denied us access, and you know, we again try to work through those issues.
If I may, Commissioner and Mr. Chairman, I just want to let Commissioner McGowan know that Mr. Knopp will be our next witness, and he may be able to speak to that a little more specifically on NOAV locations.
Yeah, on NOV location. That would be great. Thanks.
Great.
Any further questions? Mr. Jacobs, any redirect following Commissioner questions?
No, thank you, Mr. Chairman.
Then I believe we can move to Mr. Mop.
That is correct. If you'll give us a moment, he'll make his way to the witness room if he's not there already. Mr. Knopp, you've been sworn previously, is that correct?
That's correct.
And you can hear me okay?
Yep. Can you hear me?
I can, thank you. Mr. Chairman, I think we'll proceed.
Okay, very good. I was going to have A.G. Davenport remind him of the swearing, but you did that, so I think we're in good shape.
Very good. Good afternoon, Mr. Knopp. As you previously testified, you're the Director of Environmental Compliance for KP Kaufman Company, is that correct?
Yes, that's correct.
And I believe you also testified that you have a bachelor's degree in geology from the University of Colorado, correct?
That's correct.
Now, turning to the specifics of this portion of these proceedings, are you familiar with the Director's 901A order dated April 12, 2021, issued to KPK?
Yes, very familiar.
And is your work affected by that order?
Yes.
You're devoting resources to those projects?
Yeah, we devoted almost our entire resources to addressing those projects, quickly remediating and trying to get closure for these projects.
Great. Have you summarized or tracked your progress on those locations in any fashion?
Yes, put together a summary that's typically updated on a monthly basis, just to keep management apprised of the progress being made at these locations.
Mr. Knopp, I'm sharing my screen. Do you see that KPK Exhibit 15, Summary of Progress? Do you recognize that?
Yeah, that's the progress summary.
And who is that prepared for, you say?
Just for internal management for review.
And are you aware whether that's been shared with staff over the last several months as it's been updated?
Yes, I've been made aware that it has been shared.
Thank you. I'm going to also show you, if you'll look at the screen, Exhibit 16. And I apologize, it's a little small, I'll zoom in, but you can see that it's a large table, can't you?
Yeah, that's correct. It's just a summary table of that project summary.
So directing the commissioners in particular to this table, it's an easy single document reference to the progress at the different 901A order locations by these different parameters across the top of the columns. Is that correct?
Yes, that's correct.
And you prepared that?
Yes.
Thank you. Are any of those locations closed? Oh, excuse me, I'm sorry. Let's back up. I misspoke. I want to move to another exhibit. I'll go back to screen share. Bear with me. Here. Okay, now can you see this cover sheet exhibit 9?
Yeah, I see the exhibit 9. Yep.
And this is another summary, but this is with respect to NOAV locations, is it not?
Yeah, correct. Same format, just tailored to the NOAV.
And do you recall about when you prepared this latest NOAV location summary?
Yeah, it was at the same time as the 901A order summary, so that's early September.
Great. And now are any of these locations closed?
Yeah, there's a few. So we have the Amico Charter Schneider, the Nessie one, and the Gilson number 5.
Thank you. Now, earlier you said you'd made significant progress where you're able to proceed more quickly. Are there impediments to KPK making quicker progress at these locations, or at least at some of these locations?
Yeah, there can be a variety. More so recently, it's just working through an appropriate remediation plan and getting approval to move forward with that plan.
So this involves staff turnaround in some respects?
That's correct.
Can you give me some examples?
Sure. I think the, what doesn't blank on the name, the Grant tank battery and the Nessie consolidation are 2 good examples of those.
Okay. Let's talk about the Grant tank battery. What was the source of delay there in terms of getting approval for what you want to do there?
Yeah, so we've gotten to a pretty big excavation at that location, and we wanted to proceed with some probing just to get some general information about where excavation will be focusing and where would be, the direction of the excavation progress could be targeted. We've been trying to communicate that plan, and we've had, we've gone through multiple submittals with the remediation work plan, and that's been rejected multiple times.
I'm going to share a screen again with you. This time we're looking at KPK Exhibit 3. Can you see that cover sheet?
Yes.
Cover sheet?
Yeah.
This is a email chain. You see that it's emails in which you're copied and communicating with Mr. Canfield. Is that correct?
That's correct.
I've noted here that most recently in mid-August, Mr. Canfield denies the operator's request for additional soil borings. He provided a number of concerns down below this in the email strand. What's the problem with those concerns relative to your earlier correspondence with Mr. Canfield in this email chain?
Yeah, so our initial attempt was just to do this quick probing, somewhat of an investigation, but that was communicated that it needed to go through the site investigation, remediation work plan approval. So we had submitted that. He had rejected that with comments. We had addressed those comments and resubmitted. And then through this communication, it was denied again under the same reasoning. So it gave some confusion if he was even reviewing the correct remediation work plan, since multiple have been submitted over this time period.
So if I understand correctly, this came back with the very same comments as though he hadn't read your corrected Form 27?
It seemed like that, and that there was confusion just because we had made an effort to address the initial comments, but the reasons for not approving were identical from a cookie cutter.
And do you feel as though he was confused as to the purpose of your borings, only to, better delineate excavation and not for purposes of characterizing groundwater, that sort of thing?
Yes, I think there was confusion. I think there was an impression that we were trying to satisfy Rule 913 with a full site characterization and investigation, which was not the intent of this plan. We're simply probing the soil to direct excavation activities, which excavation would then be our site investigation process.
And have you been able to engage in that soil boring just for excavation purposes to date?
No, we still have not received approval for that.
And how long have you been trying to engage in soil boring at Grant Tank Battery just to help direct your excavation while you wait on approval from Mr. Canfield?
We had wanted to start this process back in March, so it's been about 6 months.
Thank you. Do you have any expectation that you'll obtain approval to do that soil boring anytime in the near future?
No, I don't believe so. Our last proposed investigation date has come and gone with no comment back on the proposed plan.
So turning to the Nesu consolidated location, I think that was your other example a moment ago that you mentioned. What's been the cause of substantial delay there?
So that one's a little different. It's associated with the repair that was made to the Nesu consolidated line.
And this involved an upgrade to polypipe, if I recall?
Yes, that's correct. So this is a location that had multiple releases, both associated with fiberglass Flowline. So a way to prevent a future release, we wanted to upgrade a portion to polypipe. So we made a transition from poly to fiberglass for that repair.
And did staff approve of that repair using polypipe?
They did not. They had concerns with the fitting utilized to make that poly to fiberglass transition.
What was the basis of their concern? Do you recall?
They believe that it did not meet the applicable technical standard required by the rule.
Are you referring to Rule 1102B?
Yes.
And that references an API standard, does it not?
It does. We were looking at, I think it was API 15S, but we didn't believe it was applicable to our specific flowline repairs. Based on our internal review, we didn't believe that standard applied to multi-material instances.
So where there's no API standard to apply under Rule 1102, what does the rule require, to your understanding?
Right. So the rule also has an or follow manufacturer's recommendations. So, and that's what we utilize for this specific repair. We followed manufacturer's recommendations and made this installation of the fitting.
And you installed that fitting and were requesting approval, the pressure test and backfill when staff said they had issues with the transition fitting?
Yes, that's correct. So there, we were in communication about the issue with the fitting. They had requested specifications on the fitting. That was provided. A portion of that spec sheet was utilized where it says it's not recommended for gas distribution. Based on that phrasing, we could not get approval to use that fitting.
Is your flow line and gas distribution service, as you understand that?
No, it's not. That Nesu consolidation line is a three-phase production line. And to my knowledge, in terms of gas distribution, that's not even the sector that Cogcc regulates.
Thank you. So how long has this dispute lasted?
Again, that communication started back up in March. So it's been about 6 months.
So did staff come around when KPK pointed out that their line was not in gas distribution service?
No, that didn't resolve it. We were hung up on how to proceed utilizing that fitting. So KPK went ahead and removed that upgraded poly section of Flowline, and we went back to full fiberglass to complete that Flowline repair, which the integrity unit was okay with. Go with that approach.
So you ripped out the poly pipe upgrade and put the same fiberglass that was originally in there back in. Not the same new fiberglass, but same construction.
Yes, that's correct.
Has staff approved the pressure testing, backfilling, and closure of that location based on the revised fiberglass only repair?
No, not yet.
And has this location been an open excavation for the entire time as a result of this impasse about the applicability of an API standard or manufacturer specs to the poly pipe repair that or upgrade that KPK made and wanted to utilize?
Yes, it has.
And is this the cornfield farmed by Mr. Patrick Ladke, a complainant in this proceeding?
Yes, I believe he's the tenant farmer at the location.
And you believe Mr. Ladke knew or knows of the staff's refusal to approve KPK's repair using a transition fitting to upgrade a portion of the line to polypipe?
I'm not sure on that, but I don't believe he's aware of that.
I'm going to share a screen again with you real briefly. Bear with me. See that cover sheet exhibit 7?
Yes.
I'm going to scroll down. This is an email with Mr. Schlagenhoff in the Flowline Integrity Unit, I believe. Is that correct?
That's correct.
And this is, of course, the most current at the top, but it extends down quite a ways over a period of time. And you see these highlighted portions regarding your arguments to Mr. Schlagenhoff that this is not a line in gas distribution service, correct?
That's correct.
And yet those arguments were unavailing with Mr. Schlagenhoff?
Yeah, I believe they had a different position that I think API 15S was applicable to multi-material, which we disagreed with.
But this email correspondence documents your impasse over the transition fitting over the 6 months and continuing?
Yes, that's correct.
Thank you. Are there other examples of staff's contribution to delay in making progress in remediation to your knowledge?
Yeah, there's a few others.
Without, in the interest of time and not going into any additional locations, I do want to ask you about staff's acknowledgement of historic contamination very briefly. Let's start with NOAV locations where you've encountered historic contamination. Grant Tank Battery, Nesu 1, and Charter Schneider. Can you speak to that?
Yeah, so those excavations where, the release that we reported was small in volume and came from low producing wells, grew in significant size just because of, the volume of historical contamination that was discovered.
And that, of course, is accepting Grant where there was no release at all, correct?
Oh, yes, that is true.
Does staff afford KPK the opportunity to engage in forensic sampling and analysis to better determine who the responsible operator is when you encounter historic contamination not believed to be the result of KPK's operations?
They'll let you do it. It's historically, it's been the position where if we encounter it during our excavation, they will want that historical contamination addressed.
Okay. And has KPK remediated the historic contamination found at its locations to satisfy staff up to the present time?
Yeah, despite, adding to the scope of work significantly, we've made efforts to go in and address all contamination discovered from a flow line release or any kind of reported release.
Very good. I have no further questions on direct at this time. Thank you, Mr. Nauman.
Thank you, Ms. Stafford. Do you have any calls?
Just a few questions, Chair Robbins.
Go ahead.
I seem to be getting some feedback. I don't know if that's just me or not.
You sound good to me, at least.
Okay. Okay, then I will proceed. Hello again, Mr. Knopp. Thanks for being with us again.
Hello.
So at the beginning of your testimony, I believe counsel walked you through the 901A order. And when I believe you testified that KPK is devoting all available resources to addressing that order. What do you mean by that?
We have, internally our crews that have, multiple responsibilities, not just remediation or spill response, items like that. But in this case, at all crews just, have been focused on addressing these locations and the other spills releases.
And how many are, quote, all crews?
I believe we're at 5 or 6 crews right now.
And how many people comprise a crew?
Could be 4 to 5 people.
Okay, so there are about 5 to 6 crews comprised of 4 to 5 people trying to address 29 open remediations. Is that right?
Yeah, it's
okay. I wanted to talk with you a little bit about what you and counsel just discussed, and that is, some of the progress that has been made on dealing with not just, I guess, remediations under the 901 order, but with respect to the NOAVs. And I believe you testified with respect to Grant Tank Battery that you wanted, or KPK wanted to engage in some probing work and had submitted multiple plans and received multiple rejections. Is that right?
That's correct.
Now, why specifically were those plans rejected?
It's my understanding that they viewed this as a site investigation plan. So there are specific requirements with how you're going to do it, the technical basis for how you're doing it, the implementation schedule, a variety of items that they need to review and understand and sign off on. In order to
and your
proceed.
submittals included none of that information, is that right?
Initially, no, because that wasn't the intention. It wasn't intended.
Oh, I'm sorry.
It was intended for a full site investigation.
And in those plans you submitted, no supplemental work was proposed. Is that right?
I don't understand that question.
The quarterly or the updates that you've provided with respect to some of these supplemental forms 27, there was no additional work that was proposed. Is that right?
No, so for the grant, we did our quarterly updates specific to sampling events and things like that, and then it was supplemental submittals that were provided in terms of work we were wanting to do to further understand addressing the soil impacts.
So for those plans you submitted, they were rejected as incomplete and inaccurate. Is that right?
I don't believe they're inaccurate. The EPS staff who's reviewing them thought they were incomplete based on his interpretation of what we were trying to accomplish.
And you mentioned that there was some confusion with respect to what was being required of KPK here. Is that right?
That's correct.
And did you pick up the phone to clarify this confusion?
Yes, we've had phone calls to discuss this.
And what was the outcome of those calls?
It seemed that it was still misunderstood about the intention of these field activities.
Okay, and I'll move on to, I believe it was the NESU consolidated facility that you were discussing with respect to the fitting. And I believe you testified that KPK didn't believe that a specific API standard applied here, and it was 15S, is that right?
Mm-hmm. That's correct.
But staff sent you their rationale for why they disagreed with you, is that right?
Just that they said it, they felt it was applicable to multi-material repair work.
Okay, and so it appears that here you've disagreed with the regulators' interpretation of their own rules, is that right?
Yeah, we didn't agree with their understanding of that technical standard, not of their rule.
And did you perhaps attempt to seek a variance from this rule as staff suggested?
We made multiple attempts to explain reasons why we used that specific fitting and why we felt it was appropriate and met the rule requirement.
But you did not attempt to seek a variance from the rule, is that right?
No, we didn't need, there was no need to seek a variance because we felt it met the rule.
Okay. So overall, it seems like KPK has multiple impasses with staff about progress of work, interpretations of rules. What do you think are the appropriate ways to resolve those impasses?
I think the NESU consolidation is a good example. We had an impasse, but we went a different route and found a solution that both parties were agreeable with.
Okay. I don't think I have any further questions. Thanks.
Any redirect, Mr. Jacobs?
No, thank you, Mr. Chairman.
Any questions from commissioners for this witness? Commissioner McGowan?
Thank you, Mr. Chair, and thank you, Mr. Knott, for being here. I don't know if you heard my conversation with Mr. Kaufman, but I was curious to know if you could tell me if there are any outstanding landowner issues and getting access to any of the sites per the NOAVs that the commission just went through.
Yes, I did. Specific to those NOAVs, I don't believe there are access issues.
Thank you.
Other questions from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you, Mr. Knopp. Appreciate you being here again. Similarly, I don't know if you heard me asking some of the questions to Mr. Kaufman with respect to training and kind of understanding, you know, the rules, especially after a particular NOAV or AOC has been confirmed. Can you just elaborate a little bit further about what you do following one of these instances and how you train staff or help ensure that you know what is required if it should happen again?
Are you speaking like instances like a Flowline release or?
Yeah, any of the matters that we you know just heard in August or the AOCs from the past. I realize that you were not in that same role through all of those AOCs, but in general, following one of these confirmed AOCs, you know, what sort of process do you undertake with the staff to ensure that everybody knows what needs to be done if it should happen again?
Yeah, well, I mean, for the AOC, I mean, it's a unique situation. So obviously that information has to be reviewed and then communicated to field operations. That's more a conversation with supervisors and having that information passed down on expectations and requirements. I think in terms of compliance with just the rules and, you know, spill or releases or remediation, that typically just falls into the typical training process, which is we do on an annual basis to cover that, whether it's spill reporting or remediation process. We go through that. That's all kind of captured in the annual training program. I think if we were to have a unique spill or release event that kind of deviated from the information that's communicated in that training process, we would have to address that on a case-by-case basis. But in terms of what we typically deal with, these flow line releases or the remediation projects, that's just kind of addressed through an annual training process.
Okay, and what about for you as Director of Compliance? You know, what process do you undertake? You know, like when there's rule changes, or just to ensure if there is an operation that is going to take place, or if in the event of a spill or other upset condition, you know, what is your process for understanding compliance?
So with rule changes, that's a little more challenging. Fortunately, those aren't as frequent as because that requires a little more in-depth analysis of, you know, what's been changed, what are the new requirements, what has to be done in the field, and that implementation. And also, there has to be an understanding, you know, a pathway to compliance on that. And typically, an agency will provide that. You know, sometimes, like in this rulemaking, you know, we see these guidances and recommendations on compliance, and this pathway to compliance kind of be a residual of finalizations of rules. So specific to this recent rule change, you know, it's been a little more challenging to keep up with achieving compliance. But I'd say in the room, it's just an internal review and assessment of the new rules and communicating that. You know that in itself is kind of a challenge, and we kind of work off that just to do our own assessment and communicate that to the field operations.
Do you kind of for yourself, for your own continuing education, I guess, for lack of a better phrase, do you review the rules periodically, or what is your, you know, how do you ensure that you can keep up with, as the Director of Environmental Compliance, that you can keep up with?
Yeah, so definitely try to, you know, be engaged as much as I can with them, and definitely refresh myself with them, and in situations where, you know, we've fallen short and there have been mistakes made and we haven't met, you know, compliance requirements, you know, it's an opportunity to look back and understand, you know, why we haven't met that and how we can better operations in the future, and you know, build communication, build processes, and do things better so that non-compliance isn't, you know, duplicated.
So you do have some of these processes in place now, following some of the past situations. You now have sort of a process of, here's what we do in this situation, here's what we do in that situation, or these are the steps in the workflow that occurs.
Yeah, and that you know, we developed a compliance plan. We try to speak to those specific issues, and you know, like an example, you know, potentially spill reporting, right? It's been highlighted in the past about potential, you know, reporting issues, and so, you know, that has been revised, and that has gone through a review process and been tailored to be, you know, be more specific on how we can meet compliance with that aspect.
Okay, and then do you ever, if an operation is about to occur, or there's an incident that has happened, do you ever just pick up the phone and say, hey, I'm not really sure what applies here, you know, can you help me, point me to the right rules, or point me to the, you know, to the issues here, or what you know, is that part of your process ever?
I haven't personally had that situation. I don't think we don't typically default to that, you know, picking up the phone and asking for, you know, what we need to do in this situation. We're hoping that our internal plans and procedures address that without having to get that clarification.
Okay, so in some cases you are moving ahead with certain operations and things because you are you feel you have appropriate familiarity with the rules.
Yes. Yeah, we you know, I can see the opportunity there if we feel like we don't have a good solution, or we have a complete misunderstanding of what needs to be done, or not understanding at all how to proceed. But yeah, we can pick up the phone and do that, but I don't believe we've had that scenario so far.
Okay. Okay, I think that's it. Thank you so much.
Further questions, Commissioner Messmer?
Thank you, Mr. Chair. Thanks to Mr. Knott for testifying again. I think, I feel like there's a little bit of theme that's going on here as far as, third parties being blamed and some shedding of ownership and responsibility. And I think that your testimony is a good example of, were there ways that you could have handled that in order to be able to comply with the regulations, to be able to speed up the remediation in these two particular situations to ultimately accomplish the goal, which is protection of public health, safety, welfare, the environment, and wildlife resources, without having this he said, she said about ownership or responsibility?
Yeah, and I apologize if I don't know if I communicated some of my testimony that's, kicking the can down the road or passing the blame. I don't feel like I was initiating any of that, but I would say that we respond and address to, these spills and releases, how we see appropriate and putting our resources to the project. There's always discussion about what's possible. It's possible we could contract every excavation company in Colorado, but it's not realistic to speed the process up. We believe we have the appropriate resources and we address it in the appropriate manner in response to these issues. So,
but you do understand that in order to be able to get closure in these particular situations, that you do actually have to have Cogcc sign off that it is compliant. And so whether or not you think that it is the right path or not, ultimately it is the regulator that determines whether or not that remediation is appropriate and successful.
Yeah, for closure, right? As you said, and what I was speaking to wasn't requesting closure. We were just providing notification of an activity you want to do to further understand the level of impact and where we will be excavating, just to give direction to an activity, not give closure, not.
But to take a step towards closure, correct?
Yes.
This is why you're doing this, and as we look forward here, there could potentially be a situation where you and KPK are being asked to, continue this relationship with the Cogcc in order to be able to come up with additional ways to remediate situations and to create closure. Do you believe that it is possible for you to be able to comply with Cogcc regulations and determinations from staff without having these conflicts?
Yeah, and I don't even think they're conflicts. We're continuing to work with them. Like with the Grand Tank Battery, we're continuously providing site investigation remediation work plans for their review and approval. We just have not received it, but we are tailoring our revisions to their comments. So we are ongoing, have a relationship with them and working with them. I wouldn't say it's conflict. It creates a delay in the process, but it's not a conflict.
Okay. Thank you.
Commissioner McGowan.
Thank you, Mr. Chair. And thank you, Mr. Knapp. I'm sorry, I have a few more questions.
Mm-hmm.
Are you the appropriate person to talk to about the consent decree with CDPHE and EPA?
Yes.
I am curious to know how your progress is going with the 41 condensate tanks. And if you're on track, if you have a plan with them, and if you're on track with them, and how many resources you're having to put toward that in addition to what you're having to address here at the Cogcc.
Yeah, so that progress is going well. We have an agreement with them, the EPA, CDPHE and the EPA under the consent decree, which gives us a phased approach in terms of compliance and needs to address the requirements within the consent decree. So it's not, all handed down at once in one heavy lift. We were given, this ability to phase in groupings of locations of those 41 you mentioned, and address those on an incremental basis. So that's going well. We are meeting those deadlines and those requirements, and we are continuing, with as we roll into these new phases, meeting those requirements and keeping up with the reporting and record keeping and all things associated with the consent decree.
Thank you. In regards to the exhibits that Mr. Jacobs showed, where you have put together kind of milestones and deliverables for the NOAVs, it looks to me like that is something that was created rather recently. And I'm wondering if you've done that in the past for your other NOAVs, or if you're doing that or have done that now in response to kind of what's happening here in front of the commission.
That level of summarization, that was more specific to the 901A order, just because we had 29 locations involved. So we needed some kind of, platform to keep all those, managed and reviewed, and look at the progress on them. So we typically don't do that. It's not that consolidated summarization. We do track individual projects but they're all individualized, not in that kind of grouping, 901A order.
Thank you.
Any further questions? All right, I'm not seeing any further questions. Mr. Jacobs, we are at our afternoon break, so let's take that. Let's return at 3:25, and then we're going to talk a little process before we get into your next witness.
Very good. Thank you, Mr. Chairman.
Thanks. Okay, we are back. It is 3:25. Thanks everybody for being consistent and getting back with us. Ms. Stafford, I wanted you to show up as well, so thanks for doing that. Just wanted to talk a little process with you guys. The commission has a hard stop at 4:30 today, so we've got about an hour left. I don't know how much longer you have, Mr. Jacobs, for the pattern of violations. You can certainly use the remaining hour for that. The commission also has an ability to start up at 8:30 as opposed to 9:30 in the morning to try to take advantage of some time. And I wanted to give you guys a chance to maybe speak with your witnesses and see if there's an ability to start at 8:30 in the morning, which could take advantage again of that extra hour. So those are the two process thoughts I wanted to lodge out there for everybody's consideration.
Thank you, Mr. Chair. Kirk, have we gotten a time check?
We did. I forwarded it to you. Should be in your email chain.
Thank you. I will inquire of witnesses about 8:30, Mr. Chairman. And we'll certainly try to be efficient over the next hour before your hard stop in POV testimony.
Okay. So why don't we reconvene at 4:25 in terms of process, and maybe you will have heard back from your witnesses by that point in time, and then we can all make a collective thought about what time we should start up in the morning. Ms. Stafford, anything further from you on the process issues I just spoke to?
Thanks, Chair Robbins. I don't believe so. We will also check with our witnesses to ensure that they would be available if that's what we choose to do.
Okay, great. Then I think we are at that place where Mr. Jacobs and Mr. Mueller can call their next witness.
Her colleague, Ms. Carlson, will be leading the direct exam of our next witness.
Great. Good afternoon, Ms. Carlson. Nice to see you.
Good afternoon.
And I see an unidentified witness in the witness chair.
That is the one. Kpk next calls Mr. Jeff Ricard.
Yeah, okay, AAG Davenport, if you could swear this witness in, I do not believe we've heard from him before.
Sir, would you please raise your hand, simply state your name and say that you swear to tell the truth?
I, Jeff Ricard, swear to tell the truth.
Thank you.
You're up, Ms. Carlson.
Thank you, Chairman. Mr. Ricard, you've already stated your name, but would you please tell us your current employment?
I am currently a regulatory tech at KPK.
And how long have you been in that position at KPK?
I have worked for KPK since June of 2020.
And what are your responsibilities as a tech there?
As the regulatory tech, I oversee and work with all our different departments to ensure regulatory compliance.
And do you have any degrees, licensing, or certificates that are applicable to that position?
I have a Bachelor of Science in Geology from Colorado State University, 2006. I am a certified stormwater inspector, and I am 40-hour OSHA certified.
And before KPK, could you just very briefly go over your other jobs that you've had in the oil and gas industry?
Prior to KPK, I was on the regulatory team at Extraction Oil and Gas. Prior to that, from 2013 to 2017, I was a field inspector with the Colorado Oil and Gas Commission in the Wattenberg field. And prior to that, I was an environmental consultant and geological consultant for various projects and firms all over the state.
Thank you. And as your time as a field inspector with the Cogcc, did you become familiar with the Cogcc system where they store data?
Cogcc was a central part of my work, and I became very familiar with it.
So now I know that you pulled some data from Cogcc, and that's related to this case, and we're going to get to that in just a moment. But before we do, I want to talk a little bit about staff's exhibits that they have presented. Have you had a chance to review staff's exhibits?
I have had a chance to review staff's exhibit 2 through 5.
And specifically, did you review the exhibits that had data compilations within them?
Yes, specifically exhibit 5.
And were you also here for Mr. Axelsson's presentation using exhibit 5?
Yes, I was.
And would you briefly just describe your understanding of what staff is purporting to show with those compilation of data?
There were 2 main graphs in there. One was a comparison with us and 6 other operators from the basin that was total number of spills versus total number of producing and shut-in wells. And there was another chart showing our total spills by year from 2017 to current.
And do you believe that those are a fair statistical comparison of KPK?
I believe if you ask several different people, you could probably get several different answers for how to compare things. There's several factors. You could compare people by production, by area, by PR and SI wells, by type of wells. But certainly it's fair game to compare them for number of wells.
And so now I want to turn to Exhibit 13, and I'm going to use the catchphrase of the day and share my screen here, so bear with me. All right, can you see my screen, Mr. Ricard?
Yes, I can.
And before we dive into Exhibit 13, I'm going to show you some graphs, and you created these graphs, correct?
Yes, I did.
And were these graphs created from the Cogcc data that you were able to pull?
All data in these graphs were pulled directly from the Cogcc database.
So let's go ahead and start with graph 1.
Okay.
What does this graph show?
This graph shows number of inspections, just the raw total number of inspections per year from 2017 through last week by year for us and several other operators in the basin.
And why these particular operators listed on the bottom of that graph?
They were in Exhibit 4, and they're geographically near us.
And based on this data, we can see an upward trend for KPK, isn't that correct?
Correct.
And let's now go to graph 2. What does this graph show?
This graph shows the ratio of inspections, just total number of inspections, to total number of wells. So it's a ratio of those 2 numbers.
And we can see that based off of this data, KPK was inspected at a higher well count ratio than the other operators listed, right?
That's correct.
Now let's go to graph 3. What does this graph purport to show?
This is the same graph as the last graph, just for the data for 2021 as of last week.
Now, if we put these two graphs side by side, what can we see?
You can see that KPK is inspected more often when compared to well count.
Now, going from number of inspections to reportable spills now. So I want to take a look at the next graph in the series here. And again, just to be clear, the reason that these data points are in CODIS is because these are classified as reportable spills, correct?
Yes, all the data for our spills is not a 19, it's an individual spill number is what compromises the data point. The numbers, I should say.
Thank you. And what does this graph purport to show?
This graph is the total number of spills compared to the total number of producing and shut-in wells for operators. This is a mimic of what John Axelsson presented, just with more data points.
And by more data points, let's kind of break down this graph just a little bit. So the blue dots, what do those represent?
The blue dots represent operators and their number of spills plotted against their total number of producing and shut-in wells.
And there's specifically a few different operators that are called out by letter. Why those specific operators?
Those are our neighbors in the basin.
And there's been a few comparisons made to extraction oil and gas. Could you point out which operator on this graph is extraction?
Extraction would be operator letter B.
And according to this data set that we can look at, where does KPK compare to other operators in regards to reportable spills since 2015?
You can see a trend line that would be expected that the more wells you have, the more spills you have. That trend line has been plotted on there and KPK is just about right on it.
And now going to the next graph, what does this graph show?
In Exhibit 5, they plotted all our spills by year through 2015. So this is the total number of spills. Oh, this graph is the total number of spills. Sorry, wrong graph. For 2021. So as of last week, this is the 2021 data.
And as of now, it's incomplete because we only have through September, right?
Yep, this is through September 13th.
And as with the last graph, all of the blue dots correspond to other operators in the basin, correct?
Correct.
And just going off of the data that you pulled out of CODIS in order to create this, what can you tell about the actual size of the spills from the data?
You can just tell they're a spill.
So you can't tell what's in the spill, any of that?
Nope, the number is based on the number of unique spill IDs.
And so again, looking at this graph and asking the same question I have been, where does KPK compare to other operators?
When you plot a trend line, KPK falls right, very close to it, so right about the average.
Now, the last graph I want to look at, it's titled Wells versus Form 27s for 2021. And before we kind of dive into this data, can you just remind us again what is the purpose of a Form 27?
A Form 27 is for when you open a remediation project, so you can get a remediation number assigned to it.
And what does this graph show, Mr. Ricard?
This graph shows the Form 27, so individual remediation numbers plotted against an operator's number of wells.
Thank you, Mr. Ricard. No further questions.
Thank you. Ms. Stafford, any cross-examination?
Just a few, thanks. Good afternoon, Mr. Ricard. Thank you for being here. We appreciate it. So in your testimony, you discussed Staff's Exhibit 5, and we had a bit of a discussion on Exhibit 13, which were the graphs that you have created here. If we could look at the well count inspection graph, do you recall the risk-based inspection protocol that Cogcc employs?
I remember, yes, they identified criteria to prioritize inspections.
And what are those criteria?
It's been many years, and I don't know if they've been updated internally.
What were the criteria when you were with Cogcc?
I'm going off the fly here. Just off the top of my head, the number one criteria was year since last inspection. And then from there, it's a little blurry. I know there was adjacent to municipalities, maybe age of the well, and a few other factors.
Okay. And are you aware that KPK has been inspected more because they have more spills?
If that's the case, then that's the case. I haven't heard any objective data to confirm that.
And KPK also has older facilities than some other operators in the basin. Is that right?
That would be correct.
And they have more corrective actions associated with their locations. Isn't that right?
I did not pull a total number of correction action count, and I haven't been able to pull that for other operators, so I don't feel comfortable answering.
Understood. And isn't it true that KPK has many complaints associated with different oil and gas locations in the basin?
Yeah, we're very adjacent to developments and cities. We're very visible.
Okay. And the data you've plotted here, does any of this show how long it takes an operator to respond to a spill? How long it's taken KPK to respond to a spill?
Nope, I just tried to mimic the data that staff presented in Exhibit 5.
Okay. I don't think I have any further questions. Thank you.
Thank you, Ms. Carlson. Any redirect?
Briefly, please. Mr. Ricard, Ms. Stafford asked you a few questions about spills associated with KPK. Do you recall those questions?
Yes.
Is it true that KPK has more spills than other operators based off of the graph we just looked at?
The data would show no, that we're pretty close to the trend line when you plot it that way.
Thank you. No further questions. Thank you.
Thank you. Questions from commissioners for this witness? Commissioner Messner?
Thank you, Mr. Chair, and thank you, Mr. Ricard. I just didn't have it clear in my notes. How long have you worked for KPK now?
Since June of 2020, so about a year and a half.
June of 2020. And your role with Cogcc was what?
I was a field inspector in the field inspector group.
You were a field inspector in the DJ Basin for how many years?
From November of 2013 to May of 2017.
13 to 17. Okay, thank you.
Any other questions from commissioners? Mr. Ricard, I believe you are off the hook. Thank you for your testimony today.
Thank you.
Ms. Carlson or Mr. Jacobs or Mr. Mueller, your next witness.
Thank you, Mr. Chairman. I think he is on his way to the witness room now. He will need to be sworn.
Okay, we will get AAG Davenport primed. Your witness room remains blank.
Our witness is on his way.
Okay.
Apologies for the slight delay.
That's okay.
Our witness is there. It's just the technology isn't cooperating.
Can you hear me?
We can hear you, Mr. Boygan. Good to see you.
Good to see you, Mr. Chair. I'll try not to remain blank.
Mr.
I
Chair,
need to be sworn, I think.
our next witness is Howard Boygan, and yes, he does need to be sworn.
AG Davenport.
Thank you, Chair. Mr. Boygan, will you please state your name and say that you swear to tell the truth?
I, Howard Boygan, swear to tell the truth.
Thank you.
Mr. Boygan, thank you for joining us today. You are known to many, maybe all on the commission. You have practiced law for 34 years in Colorado. You've been in the natural resource business altogether for at least 45 years. You were general counsel for exploration and production companies. You even sat on this Cogcc commission from May 2017 through July of 2020, appointed first by Governor Hickenlooper and then reappointed by Governor Paulus. Those are just a few of the highlights. Is all of that accurate?
Yes, it is. Thank you.
Mr. Boygan's CV is an exhibit. It is Exhibit 11. It's part of the expert report that he has also tendered for the commission's convenience. So again, thank you for joining us, Mr. Boygan. You were part of the task force in 1994 that adopted the amendment to the Cogcc rule that strengthened regulation of industry, and in particular, that was a precursor to today's Rule 525D2, which, as you know, is the subject of today's proceedings. Do I have that right?
Yes, there was concern at the time over the scope of the commission's authority on environmental and other public health, safety, and welfare measures. And activities in the DJ Basin were difficult and controversial. There was a lot of drilling. There were shoddy operator practices. The drilling was driven by a number of factors, which I've outlined in my report, my written report. There were expiring tax credits. There was the need to continue flush production on wells. And because of the uncertainty regarding who had authority to oversee this activity and really enforce the rules, industry and other stakeholders convened a task force in 1994 to try to clarify this. And it resulted in, among other things, in the amendment that became what we call the bad actor rule, which is currently before the commission in these proceedings, which allowed the commission to suspend the issuance of new drilling permits to operators who knowingly and willfully violated the law or orders or permits. It was a high standard, and it was focused on potentially cutting off future cash flow to those who basically had forfeited their social license to operate by showing that they could not operate within the law.
And although it was focused on new permits, it was still a pretty harsh sanction. Is that correct?
Well, we thought so at the time because the whole focus was on drilling that was going on at a very high pace in the DJ Basin, with a lot of harm being caused, frankly, to surface owners and other affected stakeholders.
And in the years since, you've become familiar with the more recent versions. You were on the rulemaking task force and part of the process in 2007. And as you sit here today, are you familiar with the amended rule enacted in 2014 that is 525D2?
I am familiar with that amended rule and the amendment to the statute in 2014, although I was not involved directly in the amendment process. It broadened the authority of the commission to sanction operators by suspending their certificates of clearance, which in my mind underscored the importance of finding a violation as a prerequisite for doing so, because it would cut off potentially an operator's existing cash flow, not just its future cash flow. The language talks about suspending any or all certificates, and I understood that, coupled with the language about vacating the suspension when the operator would come into compliance, I understood that to mean that there was a linkage between the potential suspension of certificates and the particular matters that constituted the violations that the commission thought warranted that severe sanction.
You wouldn't think that you might label somebody a bad actor and then suspend all of their certificates of operation.
Well, it does say any or all. So that's clearly a remedy available. And in my time on the commission, I saw that happen in a few instances, but those were mostly, what I think all, examples of operators that were small or defunct or were leaving the state or were just clearly in defiance of their responsibilities, didn't pay their fines, had evidenced an intention effectively to abandon their obligations to the state. And so that was my only experience with seeing that sort of a shutdown imposed on an operator.
So, Mr. Borgen, based on your experience and your familiarity with commission proceedings, what's the process by which this suspension of certificates of clearance, if that's going to be employed, how should that be done in your estimation?
In my opinion, it's important for the commission to consider both the scope of the challenged conduct and the severity of the potential remedy. Enforcement actions under the rule 523D2 require that a hearing be held on the pattern of violations. I take that to mean a full evidentiary hearing on the issue of pattern of violations, which would include all procedural protections, including discovery and appropriate rulings on scope. I understand, for example, that the parties here differ over whether the issue of pattern of violations was timely raised. There shouldn't be any question that the hearings focused on that issue, and the parties ought to have the opportunity to prepare fully for that issue. Here, the issue is being raised in a post-briefing enforcement proceeding concerning 8 specific NOAVs. And in fact, all of the discussion that I've heard beginning this morning and into this afternoon hasn't focused on those 8 NOAVs, or maybe has very briefly, but has mostly focused on the commission's, on the director's 901A order, which were not the subject of the enforcement proceedings in phases 1 and 2, and are hotly contested by the parties. The operator believes that it has taken adequate measures to comply with matters ordered, the matters covered in the 901A order. Staff does not think so. There has been a lot of back and forth about what kind of compliance has occurred, the reasons why it may or may not have occurred. It's essentially being aggressively litigated in this post-NOAV enforcement hearing without, in my view, the type of procedural protection that would normally be afforded in a proceeding covering this kind of a matter. And so when you're talking about potentially suspending all of an operator's certificates of clearance for an operator of this magnitude, I think due process, both procedural and substantive, requires more than simply an exchange of briefs and some testimony, some argument in a post-enforcement, in enforcement in a post-NOAV hearing.
Yeah, you make a good point for the commission's benefit. This phase 3, we call it, is given over to deciding how much the penalty should be rather than whether the penalty is appropriate, if I'm following your point. In your opinion, you've read that KPK staff proposes to suspend all of KPK's certificates of clearance. Do you think that's an appropriate remedy?
I agree with completely Director Murphy's statement this morning that it's critical for the commission, for the director, to protect the public interest, to protect against any harm to public health, safety, welfare, and the environment and wildlife. I don't see how the suspension of this operator's certificates of clearance will cause that to happen. In fact, what I worry about is that if the commission were actually to order that kind of relief, it would turn a functional company into a non-functional company. I think the request for that kind of relief is overly broad and vague. Many questions, in my mind, are raised. How long would the suspension of the certificates of clearance remain in effect? When would compliance be determined, and by what process? What if the parties disagree? What's the process for lifting the suspension? Does the suspension apply until compliance is achieved on all the matters that staff considers to be violations, even minor ones? Does it go beyond what's covered in the 901A order? Only a few wells are the subject of the actual NOVs that were covered in this enforcement proceeding, but staff proposes to suspend the certificates of clearance on all of this operator's wells, potentially up to 1,300 wells, as I understand it. So what are the operational challenges to doing this? And would there be issues in restarting those wells and bringing them back into production? And how long would that take? Interesting to me is that the rule, as it reads, talks about the commission having the discretion to suspend an operator's certificate of clearance in the singular, which suggests to me that the certificate suspended would be appropriately tailored or limited to the violation found. But even if you go beyond that, it seems to me a suspension of this magnitude ought to be considered and ordered only when the violations that are found, and by the way, the 901A order matters, as I said before, are not necessarily found violations. They are violations asserted by the director and not contested by the operator, but only when those violations are so substantial and evidence such a blatant and continuing disregard of the law that an operator effectively should not be permitted to continue to operate. I think if the goal is to get the operator's attention, it seems to me obvious that that has been achieved. These NOAVs, the fines that have already been ordered, the scope of this proceeding, the 901A order, if that does not get this operator's attention, I'm not sure what else it could be. I mean, obviously, if you shut them down, that will get their attention. But in my mind, that's counterproductive.
Well, what kind of consequences do you foresee then, Mr. Boygan, if the relief that staff has requested, the blanket and wholesale suspension of certificates of clearance were actually implemented? What do you see down the road if that happens?
Well, it seems to me that at a minimum, the operator's ability to conduct the remedial and compliance work requested by the commission, by the director, would be compromised. In the worst case, KPK could be forced out of business or put into bankruptcy. There's a real risk that the state will end up becoming, in effect, the custodians of these allegedly non-compliant facilities and maybe many others. Maybe there will be some kind of a forced sale of KPK's assets to a new buyer. But, you know, we saw, while I was on the commission, how that worked out in the PetroShare bankruptcy, where the new buyer did, in fact, come in, but only took the good wells and left the state with the wells that needed to be plugged. And so I don't have a lot of confidence that a bankruptcy on the part of KPK is going to result ultimately in a better result, in a better remedial and compliance posture for these properties or for this operator. And I think, you know, when we consider who else might be affected by those kinds of consequences, obviously there are royalty owners. The state won't get tax revenues. Creditors of KPK will be hurt. But in my mind, the main issue before this commission is whether that kind of a drastic and sweeping remedy would promote the compliance that, at the end of the day, the director wants to assure. And so what I liked actually was what I heard from Mr. Axelsson this morning, and I know, Chair, you picked up on this. He talked about a compliance plan. To me, that makes perfect sense. there seem to be some communication issues between staff and KPK, and I have no way of knowing what causes those, and yet it seems so obvious to me that there needs to be close and continuing communication between this operator and staff, and maybe that needs to be overseen by somebody, but it seems like they're not talking to each other for whatever reason, or they're not hearing each other. And maybe they're not in agreement on what actually has to be done. And so having a compliance plan, I think, is a great way to start. Making sure that KPK has the financial resources to carry out the plan is important. And maybe there could be some sort of an escrow or a sinking fund or something that puts cash every month into an account that is dedicated toward achieving compliance. I mean, there are lots of different ways you can approach this. I just don't think that shutting them down by suspending all their certificates of clearance gets the job done. It seems to me not the appropriate remedy.
Mr. Morgan, it's very helpful to hear your testimony. I thank you very much. And Mr. Chairman, I have no further direct questions.
Thank you, Mr. Mueller. Thank you, Mr. Boygan, for your testimony. Ms. Stafford, do you have cross?
No, Chair Robbins, we have no cross.
Commissioners, do you have questions? Commissioner McGowan.
Thank you, Mr. Chair. Good afternoon, Mr. Boygan. Nice to see you.
Likewise, nice to see you.
Thanks. I'm wondering if you listened in on the, was it 5 days of hearings that we had about the KPK NOAVs, and if you have an understanding of the depth and width of the NOAVs that were discussed this last month.
Thank you for the question, Commissioner McGowan. I did not listen to those proceedings.
Thank you. I'm wondering, I understand what you're saying. I'm also wondering if there is a point at which you envision that something has happened so many times that something bigger has to happen, and there's a point at which the operator continuing to operate is outweighed by the sheer number of violations or just not following the rules. And I'm not saying that that's this case, but if every time we're come upon this, we can only consider certificates of participation to remove them from the specific NOAVs that are being discussed, that seems pretty limiting in our ability to deal with a recalcitrant operator.
Thank you, Commissioner McGowan. I think that really goes to the essence of this proceeding. And I'll start my answer by saying that the 901A order itself contains a remedy that's sort of targeted toward addressing the specific violations, and that is it shuts down production from the affected wells until compliance is achieved. And so that is a tool that the director has utilized, and again, which the operator has not contested, to at least make sure that there isn't any quote further contamination, and also keeps the operator focused on getting the work done. But your question goes beyond that and says, could there be a situation where even that is not sufficient? And I would say, if the commission has an adequate basis for making a finding of a pattern of violation, and if that pattern of violation is pervasive and exhibits a violation of laws or orders, and by the way, the 901A order, I'm not sure that violations of the order have been established. The parties hotly contest the extent of the work that's been done and why it hasn't been done and whether it's been in compliance, et cetera. But all of that is to say, if you had the right situation where you had an operator before you that engaged in what I would call a flagrant and knowing disregard of its obligations to operate in compliance with law, then shutting down that operator might be a remedy available that you should consider. But I would say that where you've got an operator of this magnitude, of this many wells, of this scope, the consequences of doing that would be enormous. And I'm concerned, frankly, that there are constitutional issues underlying this. There are due process issues about whether this operator has had a fair opportunity to contest the allegations that are being made that could justify or could result in shutting it down completely and potentially putting it out of business. So it's a long answer, but I guess I would say if you're going to be considering potentially putting a significant operator out of business, there ought to be a very, very clear and substantial record justifying it.
Thank you.
Sorry, I didn't unmute. Commissioner Messner, you can now ask questions of Commissioner Boygan.
Commissioner Boygan, it's good to see you. I've got a couple of questions. I did have the opportunity to serve on the commission with Commissioner Boygan. So one of the first things that you indicated or said was that one of the reasons that these rules were put into place, the specific rules that we're debating here today, was due to lots of harm to service owners and other impacts that necessitated the need in order to be able to create rules or enforcement opportunities that a rule like this may offer. And I know that you had indicated that you did not listen to the NOAB hearings over the 5 days that we had, where we did go very in depth into, I think, around 22 now confirmed violations during that hearing process. In your opinion, at least from what you know of this particular situation, are you seeing a situation where there's some significant harm that's occurring to surface owners? Not talking about the NO 901As, I'm talking about the confirmed NOABs.
Commissioner Messner, thank you for the question. So I think I would answer the question this way. The commission would be well within its discretion and its, of course, its authority to consider that what it heard in the course of those NOAB proceedings would justify finding a pattern of violation that might justify imposing an additional fine because it found a pattern of violations which could be an aggravating factor. I can't speak to that really because I didn't sit through those proceedings, but I could understand how you might think that you needed to go there. I can't, since I didn't sit through those proceedings and I'm not familiar with the underlying facts, I can't say whether there's been some kind of a demonstrated pattern of a refusal to respect the rights of surface owners. I would be concerned about that if that occurred, but whether that amounts to a pattern of violations that would justify sweeping suspension of certificates of clearance to me is a whole other question.
Sure. And Mr. Boygan, Commissioner Boygan, in your opinion, what is the definition of a pattern of violations? You know, as we look at this, what constitutes a pattern of violations?
Commissioner Messner, it's an excellent question. You know, the statute as it initially read had the words knowing and willful in front of pattern of violation of law, order, and permit. And I understood at the time that meant it was a really high standard. You had to show knowing conduct that actually constituted a violation. of existing law, or let's say an order or a permit. Although the permits those days weren't as robust as they are now. And so, since the relief targeted was the inability to get permits to drill new wells, which would shut off the company's future cash flow and the ability to maintain its flush production and stay on the hamster wheel that a lot of these companies were on, we saw that as a pretty severe penalty. So then fast forward to 2014, and the knowing and willful language was changed and put in front of an egregious violation. And so now you've just got pattern of violations of law, rule, or order, or permit. And the new relief, which could be suspension of all or any certificates of clearance, which can be vacated by the commission when compliance is achieved, all of which suggests to me that the violation not only needs to be established by an adjudicative proceeding, but also that the compliance needs to be targeted to that violation, and the suspension ought to be linked to that violation. So I think there ought to be, at a minimum, an adjudicatory hearing of violations to determine whether violations existed. And that, I'll just say it, I know that you've considered whether the 901A order is properly before you in this proceeding. But just to me, all the debate about it today just underscores why that's troubling. I'm not saying you were wrong. I'm just saying it certainly underscores why it's important to have a full and fair process so that, the operator can be heard and the commission can decide what the appropriate remedy is. So I don't know if I've answered your question or not. I probably haven't.
I mean, parts of it. The 5 days of adjudicatory NOAV hearings, does that feel like enough for finding for enough information to potentially determine whether a pattern of violation existed in a particular adjudicated NOAV process?
Yes, absolutely.
1A. Okay.
Commissioner Messner, absolutely. It would, but it would be, of course, focused on those NOAVs and whatever conduct was discussed and litigated in those NOAVs. And if the commission thought that those NOAVs and the action and the violations it found justified suspending all this operator's certificates of clearance, that's, I guess that's one remedy the commission could order.
And in your opinion, Commissioner Boygan, and I'm talking about specific violations now, assuming that you've got an adjudicated NOAV, a number of NOAVs, and specific violations within each of those NOAVs, does it take 2 violations of the same rule in order to be a pattern of violation? Is it 3? Is it 4? Is it 7? Is it similar, or is it exact?
Commissioner Messner, I would begin my answer to that by saying that the rules that I think were at issue in those NOAVs are pretty broad rules that can encompass a lot of different types of conduct. And so I don't think that necessarily the rule itself or the language of the rule ought to be the deciding factor. I think you ought to look at the type of conduct that occurred, the extent of the harm that occurred, and the demonstrated willingness of the operator to undertake its responsibilities by performing compliance or exhibiting defiance. I think operators' attitude should be a part of this.
Thank you, Commissioner Boygan. Good to see you here today.
Thank you, Commissioner. Good to see you as well.
Other questions from commissioners? All right, I'm seeing no further questions. Mr. Mueller, did you have any redirect based upon commissioner questions?
No, thank you, Mr. Chairman. No redirect.
Mr. Boygan, you're excused. Pleasure seeing you.
Thank you, Mr. Chair. Likewise.
Mr. Mueller, we've got about 10 minutes before we need to discuss procedures and timing. Do you have a witness that would fit in with a 10-minute time zone, or do you want to start
Right.
with one?
We're running the traps on that right now. 10 minutes isn't a lot to work with when you allow for questions. But let me see what Mr. Jacobs has to contribute on this.
Mr. Mueller, I believe our next witness, Dr. Considine, is available, and Mr. Satterley will be leading that direct. So if you want to tee it up, we'll give you 10 good minutes.
And of course, we don't have to finish with Dr. Considine, and we'll just plan on hard stopping at 4:25 so that we can have time for procedure. Good to see you, Mr. Satterley. I see you're with us. Is Mr. Considine in the infamous witness room?
He is not in the witness room.
Okay,
Ms. Larson, he may need to be elevated to a panelist. He is under Tim C on the attendees list, and I believe he raised his hand. There we go.
I think we just got him to be panelist.
Tim, if you can hear us, and you can share your video and unmute yourself.
Yeah, and so, Mr. Satterley, I think the first thing we need to do is get AG Davenport to swear him in.
Of course.
Mr. Constantine, would you please raise your hand, state your name, and say that you swear to tell the truth?
My name is Timothy J. Considine. I swear to tell the truth.
Thank you.
All right, Mr. Satterley, take it away.
All right, Dr. Considine, good afternoon. You just provided your name for the record. Now, would you please describe your current occupation and area of expertise?
I'm a professor of energy economics in the School of Energy Resources and the Department of Economics at the University of Wyoming, where I teach and conduct research in applied econometrics and energy economics. I also work as a consultant providing economic analysis for litigation support, oil and gas industry trade associations, and foundations.
Thank you. And what other experiences have you had in your career that support your testimony as an expert in this phase of the proceeding?
I have published numerous studies on the economics of oil and gas, the economic and environmental impacts of hydraulic fracturing, and the economic impacts of energy resource development.
And in addition to your PhD in economics that you earned from Cornell University, in an effort to streamline this testimony, a more detailed listing of your education, relevant scholarship, and work experience is provided in KPK Exhibit 10. Is that correct?
Yes.
And finally, have you testified as an expert witness previously in regard to litigation or before this commission?
Yes, I have with regard to both.
Now, with all of that, by the way of introduction, can you tell us what is the purpose of your testimony today?
Yes, I'm testifying on behalf of KP Kaufman Company, the purpose of which is to present an economic perspective based upon my education, training, work experience with oil and gas development, and a review of the economic literature supporting civil penalty policies and their frequent recognition of a company's ability to pay as a limiting factor in the assessment of penalties and sanctions. Testimony also provides my professional opinion regarding the economic consequences of Cogcc staff proposed monetary policy and other sanctions against KPK in this proceeding, as well as the broader effect the imposition of such severe penalties and measures might have on other oil and gas operators, the oil and gas industry in Colorado, and state and local governments.
Thank you. Now, did you prepare a report summarizing your review of the economic literature and analysis in light of these and the other materials related to this proceeding?
Yes, that's correct.
Now, I was going to briefly flash this report up on the screen, which is identified as KPK Exhibit 10, but I think in the interest of time, I'll just refer to the commissioners to that Exhibit 10 and continue moving along if that's all right.
That's fine.
Thank you. So what are some of the more relevant findings and general conclusions you derived from your review of the economic literature, and in particular as it relates to the concept of ability to pay?
In my review of the economic literature, I found three groups of findings. First, increasing the severity of punishment on oil and gas firms may have two effects. First, deter them from producing these products that are sought by consumers. And secondly, these penalties could hinder their ability to manage legacy oil and gas properties. Secondly, the penalties affect incentives for environmental compliance. Setting penalties below their maximal level may enhance compliance and environmental quality by encouraging firms to share information on environmental performance and compliance. And also, there is an upper limit to a fine or sanction on any given firm, consistent with the factor of ability to pay. And then finally, if environmental penalties or liabilities are too high, a firm may seek bankruptcy protection. The end result is an abdication of environmental responsibility and reduced compliance and environmental quality.
So based on the findings that you just mentioned and your review of the pleadings in this proceeding, did you develop an opinion as to the appropriateness of the relief sought by staff as it relates to the economic and environmental consequences such measures might have on KPK and perhaps other operators within the state facing similar circumstances?
Yes, in my opinion, the relief sought by the staff could reduce environmental quality by forcing KB Kaufman into bankruptcy, which would at best delay any required cleanup of the alleged environmental violations and potentially jeopardize the eventual decommissioning of the 1,300 wells and many miles of flow lines it currently operates. In addition, the relief sought by staff may reduce incentives for other oil and gas firms to operate in Colorado and thereby reduce the technical and economic capacity of the Colorado oil and gas industry to continue improving their environmental performance.
Thank you. And can you tell us a little bit more about what you just mentioned in terms about the risks associated with regulatory overdeterrence when it comes to a company's incentives and ability to comply with those environmental rules and regulations?
Yes, what I found in my survey of the literature is that most firms comply with environmental regulations, even though the costs of compliance may be higher than any associated penalties. When violations are discovered, the most common response is to send the firm a notice of violation, ordering a return to compliance. Penalties actually are rarely imposed, and this surprised me in the literature. If penalties are imposed, they are generally less than the maximal amount, in part to avoid the adverse consequences I mentioned above, and to avert time-consuming and costly litigation, to prevent unemployment, abrogation of contracts, and other economic dislocations associated with large fines and severe sanctions.
What did you find in terms of how adjusting penalties based on ability to pay considerations may actually incentivize and enhance compliance and improve overall environmental quality in this type of enforcement context?
What I found was excessive penalties or severe sanctions may lead to over-deterrence because some firms would judge production too risky. If pollutants are persistent, regulators should consider post as well as pre-violation incentives. High penalties or severe sanctions may disincentivize firms to voluntarily remediate environmental problems, which constitutes an admission of responsibility for any damages already done. Penalties less than their maximal amount, therefore, provides an incentive to prevent pollution and to implement a cleanup program once a violation has occurred.
Now, in your professional opinion, are there any potential unintended consequences and costs that could result from imposing the maximum degree of penalties and sanctions sought by staff against an operator in a similar financial and economic position as KPK?
Yes, there are several. First, the severe fines and sanctions proposed may send the wrong signal, not just to KPK, but to other operators, leading, as I mentioned before, to over-deterrence that will discourage investment and production in the oil and gas industry, decrease employment, and reduce severance and ad valorem tax revenues to state and local governments. Secondly, imposing these maximum penalties and sanctions could lead to a reduction in environmental quality and less efficient remediation and reclamation to oil and gas locations for KPK and across the industry in Colorado. Environmental cleanup from past violations, legacy contamination, and future reclamation of oil and gas lands are most efficiently accomplished by oil and gas operators with expertise in these activities. Society faces the challenge of efficiently managing the environmental impacts of many thousands of oil and gas wells and flow lines, including those in Colorado, even as we commit to a significant energy transition. Eventually, these wells will need to be decommissioned following applicable environmental standards. So excessive penalties may discourage oil and gas firms from operating in Colorado, which could increase the cost of future environmental compliance. Imposing significant monetary penalties, in addition to constraining a company's ability to generate production revenue, can hinder a company's ability to engage in adequate and timely remediation efforts. At the extreme, over-deterrence in the form of excessive penalties and sanctions can preclude a company from staying in business, which can lead to the orphaning of assets and unfunded remediation that in many cases must instead be taken up by the state. It is the oil and gas industry in Colorado that has the technical expertise to meet these challenges and therefore is likely to be the most efficient provider of these services and remediation and reclamation responsibilities.
Now, are you familiar with the Cogcc enforcement and penalty policy in regards to what it says about ability to pay?
Yes, I am.
In your report, you discuss how innovative solutions often should be considered before resorting to severe penalties and sanctions that could result in the sort of unintended consequences you just discussed previously. Does the enforcement policy contain any such innovative solutions?
Yes, it does. Notably, the enforcement policy identifies deterrence as a primary purpose for imposing penalties and specifically allows for the consideration of ability to pay in calculating penalties and other sanctions. Two features which are consistent with my review of the economic literature. The enforcement policy and its discussion of ability to pay recognize the flexibility to reduce fines and the risk of over-deterrence by recognizing the ability to suspend all or a portion of the penalties assessed and to craft a schedule of payments to avoid the problem of over-deterrence, among other measures available to the Commission. There are good examples of innovative strategies that the Commission may wish to consider for bringing this operator back into compliance and dealing with the potential environmental impacts of legacy oil and gas properties in an economically efficient manner.
Now, as highlighted in several staff's pleadings and the testimony you heard from staff's witnesses earlier today, one of the stated goals of the enforcement policy is to ensure that penalties are administered to encourage a rapid return to compliance and to ensure that impacts are timely addressed to further the agency's mission to protect human health and the environment. In your opinion, will the imposition of the penalties and sanctions proposed by staff in this proceeding further these goals and objectives?
I do not see how the penalties and proposed sanctions by staff can promote a rapid return to compliance. Indeed, these remedies are likely to at best delay and at worst prevent a return to compliance by placing KPK under financial duress. Accordingly, the proposals by the staff are likely to hinder compliance and diminish environmental quality. Indeed, ability to pay is not diametrically opposed to the Commission's mission to regulate oil and gas operations in a manner protective of public health, safety, welfare of the environment, and wildlife, as the staff argues. The economic literature clearly demonstrates that regulators do indeed consider the ability to pay because the financial solvency of a firm directly affects its ability to comply with environmental standards and to remediate any harms incurred due to environmental violations.
All right, thank you, Dr. Considine. Is there anything else that you would like to share or draw our attention to with respect to your report and testimony provided today?
Yes, one last thought. After reviewing the facts in this matter and the related economic literature, I think economic and financial considerations are essential factors to consider when considering how the Cogcc meets its mission. In other words, the means to the Commission's mission involves financially sound and economically viable oil and gas industry to meet current and future environmental challenges.
Thank you, Dr. Considine. I appreciate your testimony, and I have no further questions at this time.
Okay, thank you, Dr. Considine. Ms. Stafford, I am going to give you the option. Would you like to do cross-examination now? And that is only if you can get it done within about 5 minutes, or do you want to, we can bring the witness back in the morning and you can do cross then?
Thank you, Chair Robbins, for the option. Staff will take until tomorrow morning if that works. I'm not sure that we can complete that in 5 minutes.
That's fine. That's why I gave you the option. Mr. Considine, we will need to see you hopefully in the morning first thing to do cross-examination and then questions from commissioners. I'm going to lodge one question for you because this way you can think about it overnight. But it seems that you're an expert in this area. I would be interested to know your thoughts, if you have any, about what other states or what other state agencies, how they apply ability to pay thoughts, concepts. I think that could be informative to the commission as we take up this issue. So I lodge that thought with you as you leave for the evening. Okay, we got a thumbs up there. I think we can allow Mr. Considine to be unpaneled, and then we will have a quick discussion so that we can attend to commissioner schedules. Ms. Stafford, were you able to determine if your witnesses would potentially be available if we were to do a 8:30 start, knowing that you're actually not on the hot seat at that time because we've still got some more KPK information going on?
Thank you, Chair Robbins. Yes, we will all be available.
Okay. What about you, Mr. Jacobs? Were you able to talk to your folks?
Yes, we'll be available earlier if necessary.
Okay. Then commissioners, I propose that we do an 8:30 start. I believe all of you have indicated to Hearings Manager Larson that that's workable. I'm seeing thumbs up all the way around. So let's do an 8:30 start. I also note that at least for the commissioners, we do not have any hard stops tomorrow afternoon, so we hope to get through this. And so with that, I believe we're looking for a motion to continue this hearing to tomorrow morning at 8:30 in the morning.
Chair Robbins, if I may first, I'm sorry.
Yeah, go ahead. No, go ahead, Ms. Stafford. I'm sorry if I didn't see you.
Could we potentially get a time check before
yeah.
we can yes, thanks.
Ms. Larson is working on that as we speak. Give me just a sec.
Yes, so KPK has 12 minutes and 59 seconds remaining. Staff has 30 minutes and 3 seconds remaining.
Thank you.
Okay. All right. Still looking for aforesaid motion to continue to 8:30 in the morning.
So moved.
Second.
We have a motion and a second. Any further discussion? All those in favor signify by saying aye.
Aye.
Any opposed? Motion carries. We will see everybody in the morning at 8:30 a.m. Thank you very much.